All right, Judge, if we can at least go over the conflicts.
Okay, and then we'll do the introductions, etc. I'll ask the scoring panelists first if you see any faces or any names that cause you to think there could be any perception of bias in your scoring activities. Would you please nod your head or just say yes, or otherwise indicate that there is such a situation? Okay, thank you. And I have none either. So Jess, I think we're clear on conflicts. Should we wait a while?
Let me get the okay that all the, yes, before we do finally get started, we'll want to make sure all the other rooms do not have conflicts, but you can move on with any other admin. Okay, well, let's, while we're waiting for that, why don't we just go through the introductory portion of this. My name is David Arkell. I am a volunteer. I'm not a real judge, although I do act as arbitrator in a lot of cases. So I have a lot of experience in real life decision making. And I have volunteered as a scorer or a judge for probably the last 12, 13, 14 years or so for the mock trial program, primarily in the tournaments, the regional and the state tournaments. But also I like to do, up until this year, I volunteer with a couple of the high schools to help them stage their practice rounds, their scrimmages. And it's really fun. I've been involved in the program overall for about 15 years. I started off as a coach when my son was in high school, and he started a program at one of the Denver high schools. And I, being the good dad and being a lawyer, I volunteered as a coach, and I really enjoyed it. I learned a lot about the program, and I really believe in the value of this program. That's why I keep doing it, even though my son's no longer in high school. God help us. But that's who I am. I've served as a scorer, as a coach, as a judge, and I'm looking forward to a good round today. I, of course, don't know anything about the students or the teams or the schools they're from, and that's the way it's supposed to be. And it's the same for the scorers as well. They are really more important than I am. They're the ones that separate the winners from the losers as far as the overall scores and the voting on the outstanding participants, attorneys and witnesses. And one of these days we may have an outstanding timekeeper award, but we haven't gotten that far yet. But I want you to think of the scorers as if they were really jurors, and behave as if that's who they are. that they are the decision makers. I'll make some of the decisions on exhibits and so on, all of the decisions on exhibits and so on, but they're the real decision makers here. Okay, I don't think, this doesn't look like it's going to be a problem, but if there is anybody who has either the audio or video on that is not a direct participant in this proceeding, that is the teams and witnesses and the timekeepers and the scorekeepers, please turn off both your microphones and your cameras, your audio and your video. Let's see, we've gone through the conflict, so we don't have a problem there. I will urge the attorneys particularly, but also the witnesses, be cognizant of the time limits. You want to finish your segment of the overall proceeding within the time limits. If you don't, you will be cut off. And if you insist on proceeding after you're cut off, the scorers have been told to take that into account in their scoring. So please pay attention to your timekeepers. When we've done it every year before this, I don't keep track of the time myself, but I like to know how much time there is left. I'm not sure I'll be able to do that with this format, but you attorneys and witnesses should absolutely be sure to do that. Okay, let's go through the swearing in ceremony. Normally we'd ask you to stand, but I have heard that nobody has to stand here when you're speaking. So just stay seated. But I would like those who are listening who are in the courtroom in the virtual gallery, please. Well, I won't even ask you to raise your right hand since I can't see you. But do you in the gallery promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? I assume everybody is nodding your head or saying yes. Team members, will you raise your right hands, please? Team members, do you promise that the presentation you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
All right, thank you. Scoring panelists, please raise your right hands. Do you promise to adjudicate this mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
All right, thank you.
Yes.
Now, witnesses, would you raise your right hands, please? Do you promise that the testimony you're about to give will faithfully and truthfully conform to the facts, procedures, and rules of mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
All right, thank you. Now I'd like each team, starting with the prosecution, to identify yourselves, your real names, and the roles you will play, starting with the prosecution.
Good afternoon, Your Honor, members of the jury, and opposing counsel. My name is Colby Lish, and today Along with my co-counsel, I'll represent the state of Colorado in the matters of the state versus Avery Becker. I will be conducting the direct examination of Detective Jordan Markowitz and the cross-examination of Miss Taylor Perkins. Permission from my co-counsel to introduce themselves.
Please.
Good afternoon, Your Honor. Good afternoon, members of the jury, and good afternoon, opposing counsel. My name is Jordan Davidson, and today I will be examining Ms. Kyle Kuzak on direct, cross-examining Mr. Blake Van Owens, as well as giving the opening statement for the prosecution. Good afternoon, Your Honor, members of the jury, and opposing counsel. My name is Zarina Yufa, and today I will be conducting the direct examination of Alex C. Fuentes, the cross-examination of Avery Becker, as well as delivering the closing statements. Permission for our witnesses to introduce themselves.
Please.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Connell Barton, and I am Jordan Markowitz.
Good afternoon, Your Honor, opposing counsel, ladies and gentlemen of the jury. My name is Louis Sharp, and I am Alex Cifuentes.
Good afternoon, Your Honor, members of the jury, and opposing counsel. My name is Chloe Brantz, and I am Kyle Kuzak.
Okay, thank you. Defense.
Good afternoon, Your Honor. My name is Juan Blas. I'm here with my co-counsel to represent Avery Becker. Today, I will be directing Taylor Perkins and the cross-examination of Alex Fuentes. May my co-counsel introduce themselves.
Please.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Daniela Guadana. I will be directing Blake Van Allen, cross-examining Detective Markowitz, and giving the closing statement.
Good morning, Your Honor, members of the jury, and opposing counsel. My name is Emily Mers. I will be giving the opening statement, directing Avery Becker, and cross-examining Kyle Kuzak.
Your Honor, may the witnesses introduce themselves?
Please.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Ramses Diaz, and I will be playing Avery Becker.
Good afternoon, Your Honor. My name is Kevin Martinez. I'll be playing Blake Van Owen.
Good afternoon, Your Honor. My name is Marisol Delgado, and I will be playing Taylor Perkins.
Okay, thank you. Let's see here. One thing I would like to cover, it's with the scoring panelists as much as with the teams. My procedure is to provide time between major phases of the trial, the hearing today, to allow the scoring panelists to stay current with their scoring. And so I will do that at least after the completion of each witness, and frequently between direct and cross, and maybe between cross and redirect, so that you can stay current with your scoring. I don't know if that was, usually it is covered in the orientation for the scoring panelists, but it's very important that you stay current. Though for the timekeepers, those pauses, when they occur, should not be charged to either side, either team. And panelists, I would like you, when you get caught up or are assured that you're current, would you look up and
try to make virtual eye contact with me so that I know we can go on to the next phase or partial phase. And if you need to, as a scorer, if you need to turn on your camera, go ahead and do that so that we can move along as efficiently as possible.
Judge, I have a question. For the timekeepers, is there a point in which you'd like them to turn their camera on to let anybody know, or were they given directions about when to come on and tell them they've got a certain amount of time left?
Well, that's a good question. Team, I guess the attorneys, have you covered that in your coaching up to this point? A process for learning in this format, how much time you have left?
Yeah, I certainly don't want the timekeepers to have to speak over any of the attorneys. So if we just want them to turn on their camera and potentially hold up something, or if just having them turn on their camera lets us know that that means there's a minute left.
We have also in prior trials, we've used the chat function. That works pretty well because we all get a notification when there is a chat sent to the chat. So we'll be able to see how much time there is left.
Is the other team okay with that? Very good.
Okay. The other thing, I had a question about it, and I'll just cover it. You may already have done so, but for the tendering of exhibits to witnesses and after they've been admitted, if they've been admitted, tendering them to me and publishing them to the jury. That process is handled through the screen share capability. And I am told that when an attorney shares an exhibit, or if there's if you're in an impeachment, you're impeaching a witness and you want to have that witness's prior testimony from his or her statement, use screen share for that as well. But at least for tendering to the judge and to the panelists, just putting it on screen share will accomplish those activities. So you don't have to do anything other than that.
Are we able to ask our timers to be the ones to screen share that, or should the attorneys be the ones?
The attorneys don't have to do it. It has to be done, but I'm okay. Didn't think about that question, but I'm okay with the timers doing it.
Agreed.
Maybe it'll help them stay awake.
Thank you, Your Honor.
Just kidding. Okay. Just so you know, I have a vision problem. I need to wear glasses, and I've got two screens in front of me. And the big one, the bigger screen that I use the most, is the one without the camera on it. So frequently I'll be looking at the big screen, not at the camera. Don't let that disorient you at all, because I'm really looking at the images on the big screen in my home office here. And so I am looking at you when you're speaking, even if it doesn't look like it on this platform. So don't let that throw you off at all. Okay. Does the prosecution have any other matters you'd like to bring up before we proceed?
Briefly, Your Honor. The prosecution asks permission to stray about our virtual wells while delivering openings, closings, direct examinations, and cross-examinations.
Well, usually I would say as long as you don't impinge on the jury's space, but I think you can wander around a whole lot virtually if you wish without doing that. So it's fine with me. Is there any response from the defense to that request?
No, Your Honor.
Okay, so ordered.
Your Honor, the prosecution requests that all jury instructions and stipulations be constructively published to the jury.
Any objection, defense?
No, Your Honor.
So ordered.
Your Honor, the prosecution requests, for the purposes of expediency and due to technicalities of Zoom, that while exhibits are being screen shared for the purposes of authentication and no lawyers or witnesses are speaking, that time be paused.
The time be what? I'm sorry?
Paused, Your Honor.
I think that's fair. Yeah, again, I haven't heard about that, but given some of the uncertainties that we all undoubtedly are familiar with in this technology, timekeepers, please do that. Does either of the timekeepers have any questions about that? Hearing none, so ordered.
Your Honor, the prosecution would like to state that for exhibit sharing, we will be using a PowerPoint. All of the exhibits shown on that PowerPoint are exact replicas of the exhibits from the case file. We thought we would point that out before screen sharing.
Does defense have any concern about that representation from counsel for the prosecution about the accuracy of the PowerPoint projections that we're going to see?
No, Your Honor.
All right.
The prosecution has no further preliminary matters.
Defense, do you have any preliminary matters?
No, Your Honor.
Okay. Let's proceed. Prosecution. Opening statement, please.
Yes, Your Honor. May I proceed, Your Honor?
May.
On the afternoon of March 6th, 2020, a masked figure breaks into the house at 444 South Flower Street. Just minutes later, this same masked figure flees, leaving carnage in their wake. A dead body lies on the floor of the patio, a gaping wound in its shoulder, while next to it, a knife drips blood. That body is the body of Mackenzie Brackman. And it is the prosecution's job today to prove beyond a reasonable doubt that that masked intruder, that was Avery Becker. Today, Avery Becker has been charged with 3 crimes: felony murder, second-degree burglary, and criminal mischief. Not only will we prove these crimes to you beyond a reasonable doubt, but we'll show you how Avery had the motive, the means, and the opportunity, and how resentment festers to anger, which explodes to fury. Let's start at the beginning. Mackenzie Brackman was a celebrated criminal defense attorney and a man generous enough to donate his time to coaching a high school mock trial team. A mock trial team that Avery Becker belonged to, at least until their expulsion. You see, Mackenzie Brackman set reasonable rules. Avery Becker thought that those rules didn't apply to him. Now, you'll see how resentment festered. You'll see this through prosecution witness Alex Fuentes, who's familiar with Avery Becker's arrogance. You'll see it through Taylor Perkins, a defense witness and Avery Becker's best friend. Ultimately, you'll see it through Avery Becker themselves. Now, this resentment
curdled to anger when Mackenzie Brackman kicked Avery Becker off the team and demoted them to B team. Rather than repent, Avery Becker manipulated Taylor Perkins into dropping the trial. Throughout this trial, you'll see how Avery Becker leads and Taylor sacrifices, puppetry at its finest. Oh, but this anger really exploded when Mackenzie Brackman just asked Avery Becker to work harder. Avery grabbed a permanent marker, stormed outside, brought the pen down on the hood of Mackenzie Brackman's car, and vandalized it. This time, Mackenzie Brackman kicked Avery off the team for good. Now you see, this was when Avery's anger exploded. Avery sent a text to Alex saying, "I'm going to break into his house and trash it." That'll show him. That'll show him. Avery intended to teach Brackman a lesson. It turned out to be a deadly one. The next afternoon, on March 6th, Avery goes to Brackman's house and flees with Brackman dead. Now, this would be enough to convict Avery, but the prosecution is going to give you more. The prosecution is going to give you Detective Jordan Markowitz, who will show you how Avery's phone was at the scene of the crime when the crime was taking place. We're going to give you Kyle Kuzak, who will show you how Avery didn't surprise Brackman, how Brackman knew an intruder was coming and grabbed a knife, how Avery, afraid, panicked, and furious, won the knife in a struggle and then brought the knife down through ribs, fascia, aorta. Mackenzie Brackman died. So as you watch this case, remember resentment, remember anger, remember fury, so that when my co-counsel, Ms. Yufa, stands up here at the end of trial and asks you to find the defendant guilty, you know the answer. Thank you.
Scorekeepers, are we ready to proceed?
Yes.
Yes. Yes, Your Honor.
Okay. Defense, please open your opening statement.
Yes, Your Honor. Good afternoon, members of the jury. My name is Emily Mers, and along with my co-counsel, Juan Blas and Daniela Guandana, I represent Avery Becker, who has been wrongly accused of killing his mock trial coach, Mr. Brackman. This case is about the police taking the easy way out and only looking for evidence to confirm whatever gut feeling they may have had. Today, you will hear from my client, Avery Becker. Avery is just a normal kid who did and said some stuff that he's not proud of, such as vandalism, but he is remorseful and did everything in his power to make it right. You'll see today that he is not a murderer, far from it. The prosecution accused Avery for the death of Mr. Brackman that occurred on March 6, 2020. As you're listening to their witnesses and reviewing the evidence they present, notice how they talk about the evidence that they think points to Avery, but ignores all the other evidence that points away from Avery. With the witnesses and evidence that my colleagues and I will present, you will see a much larger picture. One where there are multiple suspects who had the motive, means, and opportunity to kill Mr. Brackman. One suspect who is far more likely to have done it than Avery. When you consider this case as a whole, you will find that the prosecution did not do their job. They only looked for evidence pointing to Avery, ignored the whole picture. They ignored everything else. The prosecution brought this case against Avery Becker. That means that the prosecution has to prove its case beyond a reasonable doubt. Avery does not have to prove anything, but the evidence will show that the prosecution cannot meet its burden. They can prove to you that Avery killed Mr. Brackman because they ignored all the evidence pointing away from Avery. They made up their mind and then found their evidence. That's not how this is supposed to work. That's doing it completely backwards and upside down. What they should have done is go where the evidence led them. They didn't, and there is a murderer walking free. You will hear from several defense witnesses, including Taylor Perkins, Avery's best friend, and Blake Van Owen, a private investigator. Now, Taylor will talk about how long that she has known Avery and how well she knows him. You will hear from Taylor that Avery could not have committed this heinous crime because Avery was with Taylor the entire day on March 6, 2020. Mr. Brackman was killed. They skipped school to look for Avery's phone. They retraced their steps from the day before, but didn't find it. Then we have Blake Van Owen, who will talk about the missed corners the prosecution took, such as not getting the cell tower data on the surrounding towers. He'll share his findings and how the prosecution contradicts it. Lastly, you'll hear from Avery himself. Avery will tell you that he's just a normal kid who had some ugly things in his past, but that he could have not killed his coach, let alone anyone, over a disagreement in mock trial. You will also hear from the prosecution witnesses, Detective Markowitz, Mr. Cusack, and Alex Fuentes. Markowitz will tell you all the evidence that he has, but notice how he never checked Alex's phone for the screenshots that you will see later on. He only accepted them as they were given. Just one of the many mistakes taken. Then, Cusack will talk about their findings related to what they think Mr. Becker did, while at the same time looking over another suspect and not even having information on the third. They also have Alex Fuentes. Alex is also on the mock trial team with Taylor and Avery. Alex will talk about how close they are with Avery, but if you'll notice, Alex can't tell you a thing about Avery. Once you've heard from all the witnesses, it will be clear that my client, Avery Becker, was not responsible for the death of Mr. Brackman. It will be clear that the prosecution has a lot of holes in their evidence. We ask you that after you've heard from each side, that you will return a verdict in favor of the defense. Thank you.
Okay, prosecution, please call your first witness.
The prosecution calls Detective Jordan Markowitz to the stand. May I proceed?
Yes.
Detective.
Mr. Markowitz, you've previously been sworn.
Yes, Your Honor.
Detective, will you please introduce yourself to the court?
Good afternoon. My name is Detective Jordan Markowitz.
Detective Markowitz, what do you do for a living?
I am currently a homicide detective with the Denver Police Department.
And how long have you been a homicide detective?
I have been a homicide detective for the last 7 years. However, I've been working with the Denver Police Department for the last 13.
Do you have any specialized skills?
Aside from my homicide experience, I also have a certification in cell phone technology and forensic data recovery.
Do you often use this certification?
Yes, I use it in almost every case. I've downloaded the contents of hundreds of cell phones and testified in over 50 cases about using it.
Your Honor, the prosecution now moves to tender Detective Jordan Markowitz as an expert homicide detective and an expert in cell phone data recovery and analysis.
As a homicide detective and cell phone, I'm sorry?
Cell phone data recovery and analysis.
Okay. Any objection?
Yes,
Yes, Your Honor, the defense objects that Detective Markowitz is qualified as an expert in these areas. With your permission, I would like to conduct a brief voir dire of Detective Markowitz.
You may.
To receive your cell phone technology and forensic data certification, you received training, is that correct?
Yes, I completed a 3-day course with the American Academy of Law Enforcement, which I passed, including in a test.
Thank you. This training was only 3 days, correct?
That is correct.
And there was no renewal of this training, correct?
There was no renewal of this training specifically. However, I use it in almost every case I investigate.
Is that a yes?
That is correct.
There was also no other training that you received for cell phone technology, correct?
That is correct.
And you have not taken any other official training for forensic data recovery, correct?
No, no other official training aside from my usage.
And the 3-day training was from an entity called the American Academy of Law Enforcement, is that right?
That is correct.
Your Honor, at this time, I would prefer that Detective Markowitz has insufficient training to qualify him as an expert in cell phone technology or forensic data recovery. He has only received training that lasted 3 days, and the training itself was from the law enforcement.
Response from prosecution?
Your Honor, under Rule 702, to tender an expert as a witness, the witness must have one of 5 things: skill, knowledge, experience, education, or training. Detective Markowitz has extensive experience and training in the fields of cell phone data recovery and analysis. Under Rule 702, he is the qualified expert.
I will deem this witness qualified as an expert in the field of homicide detective and cell phone data recovery and analysis, as having met the requirements of Rule 702, and this witness may testify as an expert through opinion evidence. And counsel for defense, if you wish, you may pursue his qualifications for any of his particular testimony, any particular questions that may be asked of him on cross-examination. But the witness is qualified, and any alleged defects in his knowledge, skill, experience, training, or education may go to his credibility, but not to his overall qualification. Please proceed.
Thank you, Your Honor. Detective Markowitz, how are you introduced to this case?
On March 6th, I received a call of an incident on 444 South Flower Street, and I went to the scene.
What did you find at the scene?
Well, upon arriving on the scene, I noticed what appeared to be a man laying face down right inside the front door. Upon further investigation, I discovered that this was Mackenzie Brackman, and he had a large stab wound in his back.
Did you investigate the scene of the crime?
Yes, just further inside the house from the body lay a large kitchen knife covered in blood.
Now, did you have a team with you while you were investigating the home?
Absolutely.
And did your team take photos?
Yes, they did.
Did they photograph Mackenzie Brackman?
That is correct.
And did they photograph the knife?
Yes, they did.
Your Honor, I would request that our timekeeper share what has been previously marked as Exhibit 1. Detective Markowitz, could you describe this photo?
Yes, Exhibit 1 is a photo of Mackenzie Brackman laying face down just inside his front doorstep. The large splotch on his shoulder is where the knife wound occurred.
Is this a fair and accurate representation of Mackenzie Brackman on the day that you saw him?
Yes, it is.
The prosecution moves to admit Exhibit 1 into evidence.
Any objection?
No, Your Honor.
Exhibit 1 is admitted into evidence for all purposes.
The prosecution would like to request that our timekeeper share what has been previously marked as Exhibit 5. Detective Markowitz, could you please describe this exhibit?
Exhibit 5 is a photo of the kitchen knife we found laying further inside Mackenzie Brackman's home. As you can see, it is covered in blood.
Is this a fair and accurate representation of the knife on the day that you saw it?
Yes, it is.
The prosecution now moves to admit Exhibit 5 into evidence.
Objection?
No, Your Honor.
Exhibit 5 is admitted into evidence for all purposes.
Detective Markowitz, did you investigate the rest of the home?
Yes, I did. After securing the knife into evidence, I continued my investigation, upon which I discovered that no valuables or electronics had been stolen or misplaced, ruling out the possibility of a burglary. Additionally, I investigated the kitchen area where I noticed the back door was open, as well as a knife drawer next to the back door, and a plate had fallen off the table and was broken on the ground.
Did you take a closer look at the knife drawer?
Yes, I did, Your Honor. It was also photographed.
Would you recognize a copy of that photo?
Absolutely.
The prosecution would like to request that Exhibit 7 be shared. Detective Markowitz, is this a fair and accurate representation of the knife drawer on the day that you saw it?
Yes, it is.
The prosecution now moves to admit Exhibit 7 into evidence.
Any objection?
No, Your Honor.
Exhibit 7 is admitted for all purposes.
Apologies, Your Honor. Detective Markowitz, is there anything specific about the knives in these drawers?
The only thing that I could correlate between all of these knives is they don't appear to belong to any one set in particular. It appears to be an amalgamation of large kitchen knives.
Could the knife that you previously recognized as the murder weapon have fit into this category?
Absolutely.
Thank you very much. Now, Detective Markowitz, did you find any security systems in the home?
Yes, upon entering the home, I noticed that there was a Ring security system installed.
Could you briefly describe for the jury what a Ring security system is?
A Ring security system is merely a high-tech doorbell installed in the home. It is motion activated, so when a person that is approaching your home walks in front of the doorbell, it records a video and then it is sent to the person who owns the house's phone.
Now, did you look at the person who owns the house's phone?
Yes, I did. We recovered Mackenzie Brackman's cell phone and downloaded its contents.
Were the Ring videos on the phone?
Yes, they were.
Did you download the Ring videos?
Absolutely.
Would you recognize a copy of one of those videos?
100%.
Prosecution would like to request that Exhibit 12 be shared. Is this a fair and accurate representation of the video that you downloaded from Mackenzie Brackman's phone?
Yes, it is.
The prosecution now moves to admit Exhibit 12 into evidence.
Objection?
No, Your Honor.
Exhibit 12 is admitted for all purposes.
Now, Detective Markowitz, did you investigate anything else on Mackenzie Brackman's phone?
Aside from the Ring videos, I also went through the contacts in hopes of digging up further clues as to who the possible suspects may be. I noticed a large amount of contacts relating to something called mock trial, and I followed that path. Additionally, I did consider the fact that it was a possible disgruntled ex-client. However, due to the amount of mock trial contacts, I consider that to be far more likely.
Did you investigate any leads in mock trial?
Yes, I did. I received the contact information from everyone's cell phone, and from there, or received the contact information for everyone on the team. My apologies. And from there, began conducting interviews.
Who was the first person that you reached out to?
The first mock trial member that I contacted was someone by the name of Alex Fuentes.
And what did you talk about?
When I first brought in Alex Fuentes, my aim was to gather a bit more information as the goings of the mock trial team. She revealed that there had been some altercations between Coach Brackman and another team member by the name of Avery Becker.
Did you investigate Avery Becker?
Yes, I did. I attempted to call her in for an interview, but I was stopped by their attorney.
Now, Detective Markowitz, was there any physical evidence that Alex Fuentes presented to you that led to your investigation of Avery Becker?
No physical evidence was given to me at the time of the interview. However, Alex Fuentes revealed that she had text messages from Avery Becker concerning the crime.
And what were those text messages?
I later received screenshots of those text messages, and they detailed the plan of Avery Becker to break into the house of Coach Mackenzie Brackman.
Thank you very much, Detective Markowitz. Could you tell me a little bit about your investigation of Mr. Avery Becker?
Sorry, can you repeat that? You had a little bit of a cutout.
Could you tell me about your investigation of Mr. Avery Becker?
Yes. So as I was unable to conduct a formal interview, I downloaded the CDR records off of her phone.
And could you please just tell the jury what CDR records are?
Yes. So CDR records are merely a contact that your phone keeps every time it connects to a cell tower. These contacts are made every time a phone call or text message is placed, and it allows the cell company to know the general area in which you are when that cell phone or text message is made.
So, in general, are you able to track a cell phone fairly accurately with CDRs?
Yes, I am.
Is there a way to visualize that tracking?
Yes, there is.
Would you recognize a visualization of Mr. Becker's CDRs?
Yes, I would.
The prosecution would like to request that Exhibit 16 be shared. Is this a fair and accurate representation of the CDRs that you collected from Mr. Becker's cell phone?
Yes, it is.
The prosecution would move to admit Exhibit 16 into evidence.
Any objection?
No, Your Honor.
Now, Detective Markowitz, could you tell me what that black dotted line is?
Excuse me. Exhibit 16 is admitted for all purposes.
Apologies, Your Honor.
It's fine.
Detective Markowitz, could you please tell the court what that black dotted line is?
Yes, the black dotted line would be a path that Avery Becker would have taken to get from the general area in which she lived to the general area in which Coach Brackman lived.
And does the CDR data represent that path fairly and accurately?
Yes, it does. The three highlighted cones are the cell towers that Avery Becker's cell phone connected with over the course of that afternoon.
Now, Detective Markowitz, in your professional opinion, based on all of the evidence that you collected, do you believe that Avery Becker was at the scene of the crime on March 6th?
Yes, I do. Based on all of the evidence and my experience as a homicide detective, I believe that it would be logical to place Avery Becker at Coach Brackman's house at the time of the murder.
Thank you, Detective Markowitz. Thank you, Your Honor. I have no further questions for this witness at this time.
Cross-examination?
Yes, Your Honor, may I proceed?
You may.
Good afternoon, Mr. Markowitz. First, I would like to talk to you about the evidence you gathered at the crime scene. While you were at the crime scene, you took pictures of the blood splatter, is that right?
Yes, we did.
And you no longer have access to these pictures, correct?
No, unfortunately, they were corrupted.
And isn't it correct that the photos of the blood splatter are completely unrecoverable?
Yes, as is the nature of a corrupted photo. That is correct.
So no photographs of the blood splatter are here to show the jury, correct?
Unfortunately, they are not.
Next, I want to talk to you about some of the evidence in the case. After reviewing the crime scene, you interviewed Mr. Fuentes, is that correct?
Yes, I did interview.
And you did this even though you thought Mr. Brackman's mock trial activity had a small possibility of having anything to do with his death, correct?
I believe that actually Coach Brackman spent more time with mock trial than he did his actual legal work. So merely following the facts of the case, I thought mock trial was quite relevant.
In the interview with Ms. Fuentes, you learned that Ms. Fuentes didn't have his phone, correct?
No, they left it at their house.
And when you learned this, you only asked Fuentes to send screenshots of the text messages, correct?
Yes, as an expert in the field of forensic data recovery, I saw that those were the only things that I needed.
But you never confirmed or verified that the screenshots were accurate copies of what was on the actual phone, correct?
No, like I said, the screenshots are quite sufficient as an expert in the field.
But when it came to the screenshots, they were not sent until the next day. A whole day had passed, isn't that right?
Yes, that is correct.
Next, I would like to talk to you about your opinions on the cell tower records and Mr. Becker's phone in particular. You received cell tower records, correct?
Yes, I did.
And you agree that the record from the CDR identifies the cell tower that was used, right?
Yes, it does.
You also testified that there's an algorithm that pairs a cell phone with the best available tower. Is that right?
Yes, and the large majority of the time, that is the nearest tower.
You also said that the phone usually connects to the nearest tower. Is that right?
Yes, the far majority of the time, the vast majority of the time, it does connect to the nearest tower.
However, a phone does not always connect with the tower closest to it. Is that right?
Yes, you are correct in that statement. But like I stated, it is the vast majority of the time it connects to the nearest tower.
But sometimes a cell phone might connect to the tower that is further away but less busy. Is that right?
Yes, it is a vague possibility.
So you cannot base the location of Mr. Becker's phone off of the towers.
I would argue I can base the general location of Avery Becker's phone off of the towers, as the vast majority of the time it connects to the nearest one.
You cannot base the location with 100% certainty, correct?
No, not with 100% certainty.
Next, I want to talk to you about why further investigation into other suspects was not completed. You mentioned the possibility of the outcome of the case being the work of a disgruntled ex-client, correct?
Yes, I considered the possibility.
And you'll agree that investigating a disgruntled ex-client was certainly something to consider, isn't that right?
Yes, it was.
But you never considered any ex-clients in Mr. Brockman, is that right?
No, I followed the facts of the case, and that led me to where we are now.
Look at your exhibit 16, which has already been admitted. I would ask that my timekeeper bring up exhibit 16. Okay. This exhibit says Blair Rollins' house, doesn't it?
I apologize. I don't. Oh, yes, I do see Blair Rollins' house.
And you made this exhibit, correct?
Yes, I did.
So this means you're familiar with Blair Rollins.
Yes, I know of them.
And you never interviewed Blair, did you?
No, I did not. I did not see a reason to.
And you never considered her, correct?
No, I did not.
No further questions, Your Honor.
Any redirect?
Yes, Your Honor. Your Honor, may I first request that the host allow me to start my video?
Can you do that yourself?
No, Your Honor, it will not allow me to start my video. I believe that the host has to start it for me.
Okay. Jess, are you still here?
Yes, I'm sorry. What was the question?
Would you please allow my video to be turned on for a brief redirect examination?
Yeah, give me a second. Who was making this request?
Colby Lish. Thank you very much. May I proceed, Your Honor?
You may.
Detective Markowitz, why did you rule out the other suspects?
I follow the facts of the case in every case I am presented. In this case, the facts led me to Avery Becker, so I followed that lead.
Do you believe that you caught the right suspect?
Yes, I do. I believe that the conglomeration of the evidence points a clear picture to Avery Becker.
Thank you very much. No further questions, Your Honor.
Okay, Detective Markowitz, you can step down.
Thank you, Your Honor.
Prosecution, are you ready to call your next witness?
Yes, Your Honor. The prosecution calls Alex Fuentes to the stand. Permission to proceed, Your Honor?
You may. Can we have video for Ms. Cifuentes?
I believe that Mr. Cifuentes is already on the screen.
Oh, okay. Sorry. Please proceed.
Yes, Your Honor. Good afternoon. Can you please introduce yourself to the jury?
Good afternoon. My name is Alex Cifuentes. I'm that somebody that Detective Markowitz was talking about. And yes, before you ask, I can spell my name for the jury. It's Alex and Sifuentes.
Thank you, Mr. Cifuentes. I actually was not going to ask, but I was wondering if we could talk a little bit about your high school experience. What was most important to you in high school?
During high school was probably mock trial. I was a student at CHS, it's Colorado High School, and I was a member of the mock trial team.
Now, were you on the mock trial team when Mr. Brackman was a coach?
Oh, yes, yes.
And how long were you coached by Mr. Brackman?
For 3 years. We were really close, really tight.
Were you tight with anyone else on the team?
Oh, yeah, yeah. Mock trial teams have to be a unit, have to be really solid. So I knew everybody. I knew Avery, Taylor Perkins. I knew everybody quite well.
Would you say that you were close with Avery Becker?
Oh, yeah, yeah. Avery and I, well, we were best friends until the incident.
Now, as you know, Avery Becker is the defendant in today's case. However, I'm not sure that you know that Avery Becker is actually saying that you were the alternate perpetrator in this incident. What is your reaction to that?
Well, personally, I think that's ridiculous. Brackman was a role model to me. Brackman and I got along really well. It was Avery and Brackman who had the grudge against each other. Frankly, if I'd done anything to Brackman, I would have done it better.
That is very bold of you, Mr. Cifuentes. What do you mean by that?
Well, I mean that if I touched Brackman, I wouldn't be wrapped up in it at all. I wouldn't be sitting here in court today. Nobody would know it was me. Or nobody would rather think to even call me to the stand. The crime was sloppy. It was poorly executed.
Now, do you know someone named Blair Rollins?
Yeah, I do. I wave to them every now and then in the hallways.
So I would like to move now back to Avery Becker's relationship with Mr. Brackman. But first, I would like you to identify Mr. Becker for the purposes of this trial. Mr. Becker, can you please put your camera on?
Yes, that is Mr. Becker there in that black blazer.
Thank you. Now, how much did you know about Mr. Becker's relationship with Mr. Brackman?
Well, like I said, members of the mock trial team are really close, so I knew a lot about him.
And was there any tension between them?
Oh, yes, yes, absolutely. You know, at first it was the little things. You know, Avery would show up to practice late, unprepared. That really bothered Brackman, and frankly, it's understandable.
Did Mr. Brackman do anything about that from what you could see?
Well, eventually he did, but it took a lot. Right before regionals, which is a big deal in the mock trial world, Avery was actually demoted down to B team. It's a big deal because most people follow an upward trend in their mock trial career. If you're like me, you follow a really dramatic upward trend. But Avery was demoted.
Did Avery ever make it back onto A team?
I mean, you could say that. I prefer to say that he coerced Brackman to get him back onto A team, but either way, he was back.
Did their relationship improve at all after Mr. Brackman let Avery back on the team?
No. No, their relationship only went downhill from there.
What do you mean? What do you mean by that?
Ahead during the regional competition.
What happened at regionals?
Well, during regionals, Avery actually scored quite well. I'll give him that much. But he was completely unprepared. That's a consistent theme with Avery, unpreparedness. And I remember that really, really upset Brackman.
So what did Mr. Brackman do about it?
Well, after a regional competition, we had a big debrief as a mock trial team. I remember Brackman getting everybody into our mock trial room. But he told Avery that in real life, if he was that unprepared, it would be called malpractice. That bothered Avery.
So what did Avery do after that?
Well, in our mock trial room, down at the far end, we have this big whiteboard. At the bottom of the whiteboard, there's all these pens and markers. Avery went over to the marker tray, picked up a marker, and ran outside to Brackman's car.
What did Avery do once he got to Mr. Brackman's car?
Well, he was standing over his beautiful Porsche. You know, that's how you know you have a good lawyer, when they drive a nice car like that. And he takes his big red pen, writes, "Worst Attorney Award," big, bold red letters. Yeah, Brackman was pretty upset after that.
So what happened to Avery after that?
Well, Avery was kicked off the team for good. You can't come back from something like that. And frankly, he shouldn't have. It was for the best.
Did Avery ever try to come back from that?
Oh, sure. Yeah, Avery tried to apologize. He went as far as asking me to apologize for him. Apologies are one of my strong suits, but it just didn't happen.
Let the record reflect that I am asking the timer to screen share a copy of what has been previously marked as Exhibit 14. Mr. Fuentes, do you recognize this?
Yes, these are a copy of the text messages that I received the day before Brackman's killing.
Are you aware that these are screenshots of those text messages?
Yes, ma'am.
And were you the one who took these screenshots?
Ms. Yufa, I play a lawyer on mock trial. You don't have to go through all of this exhibit identification kind of stuff with me. Yes, it's all fair and accurate.
Well, if you actually played a good lawyer in mock trial, you would know that I do have to do this. Is this a fair and accurate copy of the screenshots that you took of the text messages?
Yes, they are.
Your Honor, the prosecution moves to admit Exhibit 14 into evidence.
Any objection?
No, Your Honor.
Exhibit 14 is admitted for all purposes.
Now, Mr. Fuentes, what happened after Avery asked you to apologize?
Well, that's when things got really disturbing. I remember I received a text message from him.
And what did that next text message say?
Something along the lines of, if you think Brackman was upset when he saw what I did to his car, wait till you see what I do to his house.
Can you remind the jury when this text message was sent?
Of course, that was hours before Brackman was murdered.
And are you sure that these text messages were from Avery?
Yes, there's no doubt in my mind.
Thank you, Your Honor. No further questions.
Cross-examination?
Yes, Your Honor. Good morning, Mr. Fuentes. Good afternoon, sorry.
Good evening.
So you claim that Avery Becker and you are good friends. Is this true?
Yes, it is.
But you admit that you only spend time together at mock trial and related events, right?
Yes, this is correct. I'm something of a loner. People don't like me very much. Something about my personality.
Today you testified to something that bothered you about Avery, didn't you?
What do you mean by that?
Let me rephrase the question. Are you testifying right now to something that bothered you about Avery?
Yes, Avery murdered my coach. That bothers me a lot.
You were jealous that Avery had won the award, had won the Best Attorney Award, and you didn't, right?
I think I deserved it. So I suppose yes, but that really isn't important.
You thought you should have won the award, didn't you?
Yes, but this isn't about mock trial anymore. My coach is dead. That's what this is about.
You even told Mr. Brackman that he shouldn't put up with Avery's behavior and attitude, didn't you?
Yes.
Objection, hearsay.
Your Honor, this is not being offered for the truth of the matter asserted. It is being offered to explain the witness's opinion and bias toward my client.
Response?
Your Honor, this statement was being offered for the truth of the matter asserted. This was being offered to prove Mr. Cifuentes' resentment towards Avery Becker because of the contents of the statement that Mr. Cifuentes said towards Mr. Brackman.
Reply?
No reply, Your Honor.
Objection's overruled.
Yes, Your Honor.
You say all of this despite claiming to be such a good friend, don't you?
Yes, I mean, Avery and I were good friends. It's just sometimes I didn't approve of Avery's behavior.
After Avery vandalized Coach Brackman's car, you said that Avery asked you to speak to Mr. Brackman to let him back on the team, correct?
Yes, I received that via text message.
But you thought Mr. Brackman should have pressed charges against Avery for the vandalism, didn't you?
I would have. Yes, absolutely.
When Avery asked you to speak to Mr. Brackman to help him get back on the team, you considered not approaching Mr. Brackman so that you could get a better position on the mock trial team in Avery's absence, didn't you?
Briefly, but really this isn't about positions on mock trial. Like I said, this has gotten much, much more serious.
Yes, Mr. Cifuentes, but you considered not approaching Mr. Brackman, right?
Yes.
You even told Avery to forget about the trial team and move on, didn't you?
Yes, I thought that was best for everybody involved.
Personally, you really liked Coach Brackman, didn't you?
Oh yeah. Brackman was a mentor, a role model.
You also assert that you would never have done anything to put Coach Brackman in danger, right?
That's correct.
But no one has explicitly accused you of doing so, have they?
It's my understanding that the defense today is alleging that I am an alternate perpetrator, that I might have done that. So I suppose so.
Despite this, are you apparently concerned that others think you had something to do with Coach Brackman's death? Sorry, what was that?
I apologize. Can you repeat that question?
Yes. Despite this, are you apparently concerned that others think you had to do this with Coach Brackman's death?
I suppose so. It bothers me that people would think I would do that to a role model.
You saw Avery and Taylor at the Fry Shack on the night before Coach Brackman was murdered, didn't you?
Yes.
Avery even let you use his phone to play a game that night, right?
Briefly, yeah, that's what teenagers do. Play games on our phones.
Later, you provided the police with suspicious text messages that Avery had supposedly sent to you, didn't you?
Yes, I sent them a screenshot of very suspicious messages that Avery did send to me.
Is that a yes?
Yes.
The police wanted to see your phone, is this true?
Yes.
But you didn't have it on you, right?
Unfortunately, I did not.
Because of this, you emailed the screenshots instead of providing your actual phone, correct?
Yes, that's correct. That's what Detective Markowitz told me to do. He said that was the best thing to help out in finding Brackman's killer.
These screenshots were never verified with the actual phone, were they?
Not officially, but I could definitely tell you that they are from my phone.
They cannot be verified because you don't even know where the phone is, correct?
Well, I traded it in. It didn't hold a particularly good charge, so why have a phone that doesn't hold a good charge? I traded it in after sending the text messages to Markowitz.
So you don't have the phone, correct?
No, not with me today.
And you are accused of faking screenshots you provided to the police, right?
Are you saying the defense is alleging that?
No, but you were accused of faking the screenshots you provided to the police by
Objection, lack of personal knowledge and also outside of the scope of the witness's expertise.
Spines?
Wait, sorry, what was the first objection? Sorry.
The first objection was lack of personal knowledge.
Thank you. Your Honor, this is within the witness's scope.
Well, which part of the objection are you responding to? It was first was lack of personal knowledge, and second was beyond the scope of this
On the
witness
scope of the
as
witness's
an
expertise.
expert.
I'm referencing the fact that the witness is not an expert in the fields that this question requires the witness to be an expert in.
Your Honor, I am simply asking if he was accused of faking the screenshots that he provided to the police. I'm not asking for any expert opinion.
Response, Your Honor?
Well, I'm going to overrule the objection. If this witness knows the answer to your specific question, Mr. Cifuentes, please answer it. If you don't know from your personal knowledge, say that.
Yes, Your Honor.
Would you like me to repeat the question, Mr. Fuentes?
Please, sorry about that.
You are accused of faking the screenshots you provided to the police, correct?
It's my understanding that the defense is alleging that, yes.
Avery also accused you of stealing his phone and giving it to Blair, right?
That is also correct, but again, unfounded.
But you do know Blair Rollins, don't you?
Yes, as much as anybody at CHS would.
Thank you, Your Honor. I have no further questions for this witness.
Any redirect?
No redirect, Your Honor.
Thank you. Mr. Fuentes, you may step down.
Yes, Your Honor.
I'm going to quit saying that.
Your Honor, before we proceed, may I request a brief time check for the prosecution?
I'm sorry?
Before we proceed, may I request a brief time check for the prosecution?
The prosecution has 7 minutes and 24 seconds left.
Thank you, Your Honor. And Your Honor, since we have previously published exhibits to the jury, when my witness refers to them, would you like me to screen share said exhibits, or can we presume that the jury then has them and will be able to reference them?
Please screen share them so we're all sure we have it.
Yes, Your Honor.
Please proceed.
Your Honor, the prosecution calls Ms. Kyle Kuzak to the stand. May I proceed?
You may. And you've previously been sworn.
Ms. Kuzak, my apologies, Your Honor.
Please proceed.
Thank you, Your Honor. Ms. Kuzak, what's so interesting about a dead body?
Well, I mean, the fact that it's dead. I mean, okay, I know that sounds really morbid, but you know, it's just that in my line of work, there's a dead body, and you know that dead body is there for a reason, and you want to figure out what that reason is.
What's your line of work?
Well, my technical title is a certified crime scene reconstruction investigator, but that's a super big mouthful. So we use CSR in the field.
What do you do as a CSR?
You know, it's pretty much what it sounds like. I go to the crime scene, I take the evidence back to the lab and document it. Try not to get blood all over my clothes. And then I reconstruct the scene and determine what happened. Sans actual body, of course.
So you've mentioned body a couple times. Do you typically investigate violent crimes?
Well, yeah, it's complicated.
What do you mean by it's complicated?
Literally, that it's complicated. I specialize in complex crime scenes. You know, scenes that have the greatest wealth of advanced forensic subjects, including, but not limited to, home security systems, biological evidence, and unclear event pathways. Do those crimes have to be violent? No. But do they tend to be? Yes. And so that's going to mean domestic violence, armed robberies, homicides.
Ms. Kuzak, how long have you worked as a CSR?
Oh my goodness, 19 beautiful years.
Your Honor, at this point, the prosecution moves to tender Ms. Kyle Kuzak as an expert in crime scene reconstruction with subcategories in home security systems and biological evidence.
Okay. This witness is tendered as in the crime scene analysis and reconstruction, and
with subcategories of security, of home security footage and biological evidence, Your Honor.
Any objection?
No, Your Honor.
This witness is qualified to provide opinions as an expert in the areas of crime scene analysis and reconstruction and security systems and biological evidence.
Yes, Your Honor.
Please proceed.
Ms. Kuzak, What's so interesting about Mr. Brackman's body?
You know, I would have to say it's the wound itself and the knife right by it, 100%.
Why?
Well, you know, you've got the body on the stairwell floor and you've got the knife just right there and just a couple feet away. And it's covered in blood. You've seen the photos.
Timer, would you please project Exhibits 1 and Exhibit 5? And may I ask that time be paused during this section as we pull up the exhibits?
Yes. Yes, that's a standing request, timekeeper.
Yes, Your Honor. Ms. Kuzak, this photo?
Yes. Those are the ones. The crime techs took them and used them in my reconstruction.
Now, timer, if you could quickly flip to Exhibit 5, please. This one as well?
Yeah, my crime tech buddies did that one as well.
And if you wouldn't mind stopping the share now. Thank you. So how did you use these pictures in your reconstruction?
Well, I actually frame all of my evidence in terms of a staircase.
A staircase?
Yes, a staircase. You know, there are technical terms for it, Bevel Gardner 7-step, etc. I won't waste your time on that, but the easiest way to visualize it is to think about the bottom left corner of your computer screen. And you're going to imagine connecting it with boxes to the top right corner. Now, each of those boxes represents evidence leading from the unsolved crime in the bottom left to the culprit in the top right, just like a staircase.
So these exhibits are steps 1 and 2?
Yes, they're the bottom 2 steps. You know, the body is going to start the investigation. First, how did the body become dead? In this case, it's simple, the knife. So you've got body step 1, knife step 2.
What's step 3?
Well, you have to wonder, how did the body and the knife come into contact? Did the victim wound themselves? Not in this case. You see, the wound goes through ribs, fascia, aorta. You know, that would have to be an incredibly strong blow. I mean, unobtainable at this awkward bent angle. So somebody else stabbed Mackenzie Bragman. And that's the 3rd step, but it still doesn't answer where this knife came from.
What evidence in this case does answer that question?
Exhibit 7.
So Exhibit 7, that's the knife drawer, Ms. Kuzak. Why does that answer the question?
Well, you see, there's an open knife drawer at the crime scene and a knife block with the missing knife. So conceivably, the knife could have come from either of those places. You know, there are enough loose knives that the brand of the knife really doesn't matter here. And either way, it suggests that the weapon came from the house. Of course, the next step would be to use security camera footage to be sure of this.
And we watched security camera footage in Exhibit 12 earlier. What does that say as to how the knife got into the house?
Well, in the video, I want you to, you know, take your brain back a little bit when that video was going on. Think of it and just think of the intruder's clothing. There would not be a room for a knife of this size to fit in them. So this confirms step 4.
So what does it mean that the knife came from outside the house?
Well, what I'm saying is that the knife could not have come from outside the house. It came from inside.
My apologies, Ms. Kuzak. Thank you for the clarification. So that seems odd that the knife came from within the house. Why is that important?
That's important because really what this is going to lead us to think is we say, well, who picked up the knife in the house? Because we know that the intruder did not bring it in.
So who did pick up the knife?
Well, what this means is that since the intruder didn't bring the knife, Brackman was likely alerted to the intruder's presence. And since Brackman knows the house better, Brackman knows where to get this knife, that Brackman had the knife first rather than the intruder.
Objection, speculation.
Response, Your Honor? Your Honor, this is admissible testimony pursuant to Rules 702, 703, 704, and 705. Ms. Kuzak is allowed to tender an expert opinion. This expert opinion is based on facts. This expert opinion is not about a mental aspect of the ultimate issue, so therefore is allowed under 704. And Ms. Kuzak does not have to give every single underlying fact as to this opinion pursuant to Rule 705.
Reply.
Your Honor, Ms. Kuzak was not there at the time of the crime and therefore cannot tell us exactly what could have gone on and who had the weapon and basically what she was describing before I objected.
May I respond, Your Honor?
It's not necessary. The objection is overruled. This is an expert opinion provided by a person who's been qualified as an expert in the field that this question relates to. So please proceed.
Yes, Your Honor. So Ms. Kuzak, for time purposes, can you give us a brief rundown about what happened in the house and what those steps are on your staircase?
Sure. Let's see where I start. Since the intruder didn't bring a knife, right? I've already stated that means that Brackman ultimately got to the knife first since he knows the house better. And it means there was some kind of scuffle, which is backed up by steps 6 and 7, the scuff marks by the door and possibly the broken plate. And so ultimately, my thinking here is that somebody who does not bring a murder weapon to the scene of the murder and someone who's jumped by an armed homeowner does not seem to me like a planned murderer. So that would be step 7 on my staircase. Step 8.
Step 8?
Well, you read the text messages that Avery Becker sent. Planning to trash Brackman's house, not commit murder. Avery's phone was near Brackman's house at the time. Step 8, Avery Becker.
Thank you, Ms. Kuzak. That's all we have time for. Your Honor, I have no further questions for this witness at this time.
Okay. Cross-examination.
Yes, Your Honor. May I proceed?
You may.
Ms. Kuzak, you testified that you have 2 key principles that guide your work, correct?
That is correct.
One of these 2 principles was assuming every case is going to trial, right?
Yes.
And the other is memorializing, documenting, and organizing evidence with a mindset of future reconstruction, right?
That is correct.
Now, with a mindset of future reconstruction, what that means is that you are trying to be as detail-oriented as possible when investigating a case, right?
Absolutely. I 100%.
Compound question. I would just ask that for clarity, opposing counsel break that up.
I'm sorry, what was your request? Ms. Davidson, what was your request?
That opposing counsel asked a compound question. I would just ask that they break it up for clarity's sake.
Your Honor, if I may?
You may.
I was just reciting one of the principles that Ms. Kuzak has when going over evidence. So I was just saying exact wording of the second principle.
Overruled.
Yes, Your Honor.
Thank you, Your Honor. Would you like me to repeat my question, Ms. Kuzak?
Yes, please.
Okay. Now, with the mindset of future reconstruction, oh, my bad. As a part of your memorizing, documenting the evidence, it's true that you wrote up a witness information tracking sheet, isn't it?
I do have my tracking sheets. Yes, I love those.
And on the witness information tracking sheet, you had 7 different witnesses that you identified in this case, right?
That is correct.
May I be heard under Article 10? Your Honor?
I'm sorry. I missed the question or the comment. I'm sorry.
Yes, Your Honor.
Go ahead.
Opposing counsel asked about the contents of Ms. Kuzak's spreadsheet. I would ask that this evidence be admitted as an original copy is required to be admitted before the contents of it is testified to.
Overruled. You may proceed, counsel.
Thank you, Your Honor. Ms. Kuzak, would you like me to repeat my question?
Well, that's okay. I have a spreadsheet. That's what you asked about, right?
Yes.
Yeah, I've got
So, to continue, isn't it true that you also have identified 3 different suspects in this case, right?
You know, 3 different suspects are on that sheet. However, I am the crime scene reconstruction investigator, and so looking into this isn't the main part of my job. Actually, Mr. Markowitz and other investigators are the ones who conducted these interviews.
Ms. Kuzak, if you wouldn't mind only answering yes or no to my further questions from now on.
Sure. I just want to make sure the jury isn't misled here.
Oh, yes, of course.
I didn't conduct these interviews.
I didn't say that you were. I just said that you identified 3 different suspects in this case, right?
Correct. Yes.
Yeah. One of these suspects is Avery Becker, correct?
Correct.
The other one is Alex Fuentes?
Yes.
And the last one is Blair Rollins, right?
That's funny. I recall, are you referring to Exhibit 17?
Yes, I am. I
don't recall Blair Rollins being on that spreadsheet.
Well, if you would, Your Honor, at this time, I would like to show opposing counsel what has been previously marked for identification purposes, Exhibit 17. If my timekeeper would please show that on the screen. Thank you. Now, Ms. Kuzak, do you recognize this document?
I do. Yes.
And do you happen to know who made this document?
Pardon? What was the question?
Do you know who made up this document?
I have reviewed this document.
No, I'm sorry. Let me be more clear. Do you know who made up this document?
Yes.
And who is that?
I believe you are supposed to be asking yes or no questions.
I'm sorry, what?
Didn't Mr. Markowitz write up this document?
Well, Ms. Kuzak, if you look at the top left corner, it has your first name and last name.
Yes. Yes, this is my spreadsheet. Yes.
Yes. So is this a clear and accurate representation of your CSR witness information tracking sheet?
Yes.
Okay, thank you. And Your Honor, I would like to admit Exhibit 17 into evidence.
Any objection?
Yes, Your Honor, I'd object under hearsay.
Response?
Your Honor, this document was made up by Ms. Kuzak, who, I'm sorry. I'm sorry about that. sorry, girl. This document was made up by Ms. Kuzak, who is an expert in crime scene analysis and reconstruction, with a subsection in housing and biological. If you'll please give me a moment. I'm sorry for the delay. Your Honor, this document is hearsay, but it is an exception under repeatedly made business record.
Your Honor, my apologies. Sorry, I'm knocking things off my desk. If opposing counsel wishes to admit this as a business record, I would ask that the proper foundation for that exception be laid first.
You may ask that. If you wish, counsel, this to be admitted as a business record exception to the hearsay rule, please lay a proper foundation with this witness.
Of course, Your Honor. Ms. Kuzak, why did you make up this witness information tracking sheet?
Well, to keep track of the witnesses, exactly. It was to help me do my job and figure out what happened here.
Have you made one of these before?
Many, yes.
So would you consider it a recurring business record that you do to be able to do your work effectively?
Yes.
Your Honor, at this time, I would like to admit Exhibit 17 into evidence.
Your Honor, proper foundation still has not been laid. Under Rule 806, opposing counsel still has to establish 806A that the record was made at or near the time, or with information transmitted by someone with knowledge. Other than that, Your Honor, I have no objection.
The objection is overruled. Exhibit 17 will be admitted into evidence for all purposes.
Yes, Your Honor.
Thank you, Your Honor. Continue, Ms. Kuzak. So that was the witness information tracking sheet that we were discussing before I admitted it into evidence, correct?
Correct.
Okay. And you testified earlier that one of the suspects was Blair Rollins, right?
No, I'm sorry. That document was just up on the screen in front of everybody. And nowhere on that document is Blair Rollins' name.
Okay. Now, to move on from that, isn't it true that if Blair Rollins' name was not on that sheet as the 7 recorded, you have no information on Blair, do you?
No, that is incorrect. It just means that she hasn't been interviewed.
Which means that you have no information on Blair, right?
Well, yes, I suppose so, but...
Thank you. So to clarify, you have 3 suspects in total, right?
Correct.
And you have no information on Blair because her name is not on that sheet, right?
That is correct. Blair Rollins is not on the spreadsheet.
And isn't it true that no one has seen or heard from Blair since around the time of Brackman's death, right?
I cannot testify to this. I don't know what anyone has seen or heard. My apologies.
So you can't tell the jury truthfully that you know anything about Blair, I'm sorry, including where she was on the day of Mr. Brackman's death, right?
No, I don't know anything about any Blair. I don't even conduct these interviews. It's my job to investigate the crime scene.
Ms. Kuzak, you did make up a witness information tracking sheet. And you already identified witnesses on this tracking sheet. And you mentioned Blair's name, so that must mean that you know a little bit about Blair, right?
I suppose so, yes.
And Ms. Kuzak, you cannot truthfully tell the jury that you know where Blair was on the day of Mr. Brackman's death, do you?
I do not know where Blair was.
So Blair could have been at home at the time that Mr. Brackman was killed?
Sure.
And Blair could have been at the mall at the time Mr. Brackman was killed, right?
Sure, yes.
Now, Ms. Kuzak, you do not know if Blair was at Mr. Brackman's house at the exact time that Mr. Brackman was killed, do you?
Blair could have been on Pluto, man.
Ms. Kuzak, you do not know where Blair was, do you?
No.
Thank you. No more further questions, Your Honor.
Your Honor, no redirect required from the prosecution.
Okay, thank you. Ms. Kuzak, you may step down. Does the prosecution have any further witnesses?
The prosecution rests, Your Honor.
Is the defense ready to proceed?
Yes, Your Honor. We would like to call Taylor Perkins to the stand. Good morning, Mr. Perkins. Can you please state your full name and spell your last name for the record?
Yes, my name is Taylor Perkins, Perkins.
Thank you, Ms. Perkins. And what is your occupation?
Currently, I am just a student at CU Boulder.
What is your relationship with Avery Becker?
Avery Becker is my best friend, and I've known him since high school.
In high school, what did you and Avery do together typically?
Well, we did mock trial together, and in addition to that, we also went to the mall together a lot and to the Fry Shack.
What was Avery's reputation as a participant in the mock trial team?
Well, he was known as, one of the best lawyers. He was really good at being an attorney and, just everything that involves mock trial.
How well did Mr. Becker get along with his other teammates?
Well, a little rocky at times. Like I said, he was a really good lawyer. He was really good at mock trial, and some people wouldn't, or some people just didn't appreciate that, didn't like it, or were jealous. People like
Speculation.
What's the objection?
Speculation, Your Honor.
Response?
Your Honor, I am simply asking. Wait, sorry.
May I clarify, Your Honor?
The objection is sustained for now. You may re-ask or rephrase the question.
Was there anyone in particular that Avery did not get along with in the mock trial team?
Yeah, that would be Alex Fuentes.
So how would you describe your teammate, Alex?
Well, from what I've seen from being in practices and hanging out with him because we are in mock trial together, or we were in mock trial together, he seemed to be jealous of Avery and his, success or ability in mock trial.
And where were you on the night of March 5th?
That night, Avery had actually come over to my house after going to a practice, and then Coach Brackman kicked him out. He said he couldn't be in the practice. Avery actually went to try to talk to him, but Coach wouldn't hear of it, so Avery came over to my house.
And what did you do after he came over?
Well, we hung out for a while, played video games, and we actually got hungry, so we went to the fry shack.
Who did you interact with at the fry shack?
We saw the mock trail team. They had come right after their practice, and they were just coming in to eat.
What other interactions did you have at the fry shack?
Well, we saw Alex there, and he actually approached us, and we talked about Avery being, kicked off the team and how it was unfair, stuff like that.
Response?
Your Honor, I'm not asking about any specific statements, just what happened. The witness is not speaking about a conversation that happened.
Response, Your Honor.
Reply, yes.
Your Honor, if the testimony that opposing counsel wants to elicit is simply that there was a conversation, I would ask that the conversation, the contents of that conversation be stricken from the record, as if they're not being used for the truth of the matter asserted and they are not relevant, then they do not pass the relevance test.
Well, objection will be overruled. This may be borderline hearsay, but it's pretty much background as far as its purpose, if I understand correctly. So the objection is overruled, and you may continue that line of questioning, but be aware of the possibility of hearsay.
Thank you, Your Honor. What were you doing the next day on March 6th?
Well, March 6th, I was with Avery basically all day. We were actually looking for his phone.
Do you have any idea about how Avery lost his phone?
Well, I do vaguely remember his phone being on the table the night prior while we were at the fry shack. At that time, it was only me, Avery, and Alex who were near the table. Avery had actually tried to distance himself a little from Alex because, like I said, their relationship isn't, that good. So he went to the bathroom to get a little bit of space or fresh air, and me and Alex were just sitting at the table talking. Once Avery was done with the bathroom, he came back, and we actually left. We went to the mall for a little while.
How did Alex react to Avery getting kicked off the mock drill team?
Well, to me, from what I saw of him, he appeared happy, glad that Avery was kicked off the team. Because now he could have, the chance to have all the parts that he wanted, and be that spotlight in the mock trial team.
Speculation.
Response?
Yes, I apologize, Your Honor. Your Honor, my witness is not asking, I'm not asking to speculate. I'm asking what he knows about this, what she knows about the situation.
Response, Your Honor.
You may.
Your Honor, pursuant to Rule 701, this witness may testify to their rationally based perceptions of how Alex seemed to appear after Avery was kicked off the team. However, testifying to why Alex felt that way is speculation.
Okay, the objection will be sustained, and I'll just caution both counsel and witness that please try to limit your questions and your answers to what you have observed, what you did observe, as opposed to what you think, or being asked what you think someone else thought or felt. That can be admitted under some circumstances, but it is not appropriate now. So the objection is sustained.
Ms. Perkins, when did you learn that Avery lost his phone?
I learned it the morning of March 6th when he came to pick me up. That's when we decided to look for his phone.
And where did you look for the phone?
We retraced our steps at the mall from the day prior. We went to all the stores, and when we couldn't find it, we eventually went to the Fry Shack to see if he had left it there like I thought.
Did you ever find Avery's phone?
No, we searched all day, everywhere we thought it could be, but we just couldn't find it.
Then what happened at the Fry Shack?
Well, when we went, our last stop to search for the phone was at the Fry Shack, and we were actually surprised to see the mock drill team. It was surprising because they were supposed to be in practice, but as it turns out, we found out that Coach Brackman had never showed up to practice.
So we've heard some testimonies today that Avery and Coach Brackman had a disagreement. Do you know anyone else that had something against your coach?
Sorry, can you repeat that?
So we've heard some testimonies today that Avery and Coach Brackman had a disagreement. Do you know anyone else that had something against your coach?
Well, the only person that comes to mind is Blair Rollins.
Why do you say Blair Rollins?
Well, I know that Coach Brackman I know that Blair hated Coach Brackman because he was the one that put his father in jail after losing a case.
Objection. Speculation.
Response?
Personal knowledge.
Your Honor, this is not speculation. I am simply just asking why my witness would think that Blair Rollins would have something against the coach.
Response, Your Honor.
Yes.
Your Honor, this witness is testifying that Blair Rollins hated Mackenzie Brackman. That is inherently speculation, and there has not been proper foundation laid to why this witness would believe such a thing. So I would object under lack of foundation as well.
Response to that?
No response, Your Honor.
Well, I'm going to sustain the objection and again caution counsel and witness that if you want this witness to testify as to what another person may have thought or felt, please try to elicit physical manifestations, observable manifestations of that thought or feeling or emotion. What did this witness observe that might lead her to think that someone else was feeling something? But a bare question as to what the witness may think someone else felt is not enough. So sustained.
Yes, Your Honor. Can you tell me more about Blair Rollins and Coach Brackman's relationship?
Well, like I said, Coach Brackman was kind of the reason that Blair didn't have his father anymore. To me, if I didn't have my father anymore because of a specific person, I wouldn't particularly have a good relationship with them. I would be angry at them, and I would be sad that I didn't have my father anymore. So yeah, Blair didn't, well, I would assume, well, to me it seemed as if Blair Rollins wouldn't have had a good relationship with Coach Brackman.
Your Honor,
Also,
again, I refresh my objection of speculation and lack of personal knowledge.
Response?
Your Honor, the witness is just giving her point of view of her observations on the person I'm asking about.
Well, it's legitimate for this witness to characterize her own or to describe her own feelings or her own emotions based on facts that have been testified to. But the extension of those to another person steps over the line. So to that extent, the objection will be sustained again.
Yes, Your Honor. Do you know if Blair was at school on March 6th?
actually, he wasn't at school that day.
Finally, would you lie for Avery?
No, I wouldn't lie, especially about this. This is a very serious thing, you know? And I've known Avery for a really long time. I know that he isn't a murderer.
Objection,
He
Your Honor.
would never do something like this.
Objection, Your Honor. Pursuant to Rule 608, character evidence of truthfulness is not permissible unless it is first attacked, unless the trait is first attacked for untruthfulness on cross-examination.
Response?
Yes. Your Honor, as the witness stated, she said that she has been a friend and has known Avery for a long time. Yes.
Well, the objection will be sustained pursuant to Rule 608 if this witness's credibility is put in question by cross-examination or otherwise. Then you may pursue that line of questioning, but otherwise you may not. So sustained again to that extent.
Thank you, Your Honor. I have no further questions for this witness.
Defense, please call your next witness.
Your Honor, may I request a brief cross-examination?
Oh, I'm sorry. Got ahead of myself. Yes, please do so.
May I proceed?
You may.
Ms. Perkins, you've known Avery for quite some time.
Sorry, 1 second. Can you repeat the question?
You've known Avery for quite some time.
Yes, I have.
Schooled together for many years.
Yes.
You're best friends.
Yes.
You joined mock trial to be with Avery.
Well, yeah, I wanted to hang out with him.
And you spend a lot of time with him on mock trial.
Yes.
Naturally, you've observed his interactions between him and Coach Brackman.
Yes, I have.
And you've noticed there's tension.
Yes.
They would fight.
Yeah, they would argue.
The fights would escalate.
In some instances, yes.
Avery would yell at Brackman.
Can you repeat that?
Avery would yell at Brackman.
Yes, and Coach Brackman would kind of yell back.
Now, in one of those instances, Avery got especially heated.
What instance?
The instance where Brackman demoted Avery to B team.
Yes, he did.
Now, after Avery was demoted, Avery tried everything to get back on.
Yeah, he really likes mock trial.
He wrote to you.
About?
He wrote to you about getting back on the team.
Yeah, he was asking a lot of people if they could help him.
And he wrote to Alex Fuentes.
Yeah, which really shows how desperate he was because he didn't like Alex.
Right. He was quite desperate to get back on A team.
Yeah.
And this was while he was on B team.
Yeah.
Now, Ms. Perkins, you decided to help him.
Yes.
In order to force Brackman to let Avery back on the team, you abandoned your own position.
Well, I was never really serious about mock trial, and I did know that Avery really enjoyed it. It was one of his favorite hobbies. So in observing that, I was like, yeah, I should back down for my friend. You know, he wants to be on the team, and it's his last chance to be on the team since he was a senior. So I did back down. I just kind of quit.
Right. You quit A team.
Yeah.
Because Avery wanted to be back on.
Yeah, from what, I chose to do it.
Let's talk about the night, or rather the day of March 5th, the day before Mackenzie Brackman was killed. You were spending time with Avery that day.
Yes, we were looking for his phone.
Right. And you ran into some people at the Fry Shack.
Can you repeat that?
Excuse me, sorry. The day of March 5th, the day before Mackenzie Brackman was killed. Avery had his phone on March 5th.
What?
Avery had his phone on March 5th.
Yes, like I said, I do remember seeing it.
You played on your phones together that evening.
I don't recall that.
Ms. Perkins, is it your statement in court today that you did not play on your phone that evening?
I did not. I don't remember that.
The evening of March 5th.
I didn't.
Objection, Your Honor, outside my witness scope.
Response?
I believe that whether or not this witness played on their phone on the day of March 5th is well within this witness's scope and perhaps within this witness's testimony, sworn testimony in her statement.
Reply?
Your Honor, the question that they played on their phones is not in my witness's scope of knowledge.
Well, the objection is overruled. You may proceed on this line of questioning.
Thank you, Your Honor. If you'd give me just a moment to review the statement. For the sake of expediency, let's just move on, Ms. Perkins. You and Avery, on the day of the 5th, you met together, correct?
Yeah.
You went to the mall.
Yes.
And then you went to the Fry Shack.
Well, we went to the Fry Shack before going to the mall.
You recall that Avery had her phone in the Fry Shack.
Yeah, he had his phone. I specifically saw it on the table.
Now, Avery got heated that night.
Can you repeat that?
Avery got heated the night of the 5th.
Not really. He just wanted, to distance himself a little from Alex.
Your Honor, may I request that my timekeeper share a copy of this witness's sworn statement?
Yes.
Line 63, please. May the record reflect that I'm showing the witness a copy of what has been previously marked as their affidavit. It is unmarked. May I request that this time is not taken out of our cross-examination time, as there seem to be technical difficulties.
I think that's the rule we're under, and if
I'm sorry, did you want the Taylor Perkins affidavit?
Yes, please. Now, will you please scroll to line 58? Now, Ms. Perkins, it is your statement in court today that you did not play on your phones on the night of March 5th.
Yeah, we didn't play on our phones.
And you wrote a sworn statement for this court.
Oh, sorry. I thought you meant we played on our phones at the Fry Shack. Your timeline was a little weird.
No,
we
Ms.
did play.
Perkins.
We
On
did
the
play
night
at home.
of March 5th, you played on your phones with Avery Becker. That is your
Yeah,
statement.
at my house.
Your statement in court
Yeah.
today is that you did not play on your phone.
Well,
Action
I thought you were
argumentative.
talking about the Fry Shack.
Let me, counsel and witness, please speak one at a time, especially on this, in this format.
Yes,
I think it's your turn, Mr. Lish.
Please read along silently as I read aloud line 58. So Avery swung by my house and we hung out and played games on our phones for a while. Later that evening, we went to grab something to eat at the Fry Shack. Did I read that correctly?
Yeah.
Now, please turn your attention to line 63. Please read along silently as I read aloud. Avery got upset and kind of stormed off to the bathroom. Avery's phone was still on the table, I think, which showed how upset Avery was. Did I read that correctly, Ms. Perkins?
Yeah.
Thank you very much. You may stop the screen. Now, Ms. Perkins, let's talk about why Avery was upset. Avery got kicked off the A team.
Yes, I've said that multiple times already.
Right. Avery got kicked off for vandalizing Coach Brackman's car.
Yes. For that, he was very sorry. He even offered to, get a job to pay for painting it again and fixing it.
Now, you only know about the events of this night because Avery told you.
Events of what night?
Excuse me, the events of the day that Avery was removed from A team.
Yes, I do.
Now, Avery told you that he made a mistake.
Yeah.
Avery told you that the mistake was using a dry erase marker.
Yes.
Avery didn't tell you that he felt regret.
Well, this was right after the incident.
Avery didn't tell you that he felt remorse.
Like I said, this was right after the incident.
Let's talk about the day that Mackenzie Brackman was killed. You and Avery were together that entire day.
Can you repeat that? I didn't hear the first part.
You and Avery were together for the entire day that Mackenzie Brackman was killed.
Yes, we were. We were looking for his phone, which was lost.
You went to the mall.
Yes, we backtracked our steps of the day prior, which included the mall and the Fry Shack.
And you went to the Fry Shack, yes. You did not go to school, Ms. Perkins.
No, we skipped school to look for his phone.
But you don't say where you went in the mall.
Well, we went to all the stores we went prior.
But you don't specifically say where you went in your witness statement.
No, I don't.
And you don't say how long you were there.
How long I was where?
In the store.
The first time or while we were looking for his phone?
While you were in the mall, you do not say how long you were there.
The night of the 5th?
The day of the 6th.
No. Sorry, your timeline is a little mixed up. It's confusing.
No, on the day of the 6th, you said that you went to the mall and the Fry Shack on March 6th, the day Mackenzie Brackman was killed. You do not specify how long you were at the mall.
No, I do not.
Thank you very much. You were contacted by attorneys for this case.
Yes, I was.
And afterwards, you immediately called Avery.
Well, yeah.
And Avery told you that Blair Rollins could be a suspect.
Yes.
And Avery told you that Alex C. Fuentes had fake texts.
Yeah.
Ms. Perkins, Avery Becker told you to tell us that you were at the mall.
He didn't tell me to do anything. It's what happened.
Your Honor, I have no further questions for this witness at this time.
Counsel, any redirect?
No redirect, Your Honor.
All right, thank you. Defense, please call your next witness.
Defense calls Blake Van Owen to the stand. Good evening. Could you please state your name for the record?
May I ask for why that was started?
What is the student's name?
Kevin Martinez.
Kevin Martinez.
I'm not hearing anything.
I'm sorry, Your Honor, there appears to be technical difficulties.
There he is now.
Kevin?
Can you hear me?
Yes,
I can
Kevin,
hear
you're
you
all set
now.
up now.
Yeah.
Okay. Sorry about that.
Don't worry. Good evening. Could you please state your name for the record?
Hello, my name is Blake Van Owen.
Mr. Van Owen, I am going to first ask you about your expertise. What is your role with respect to the case?
I was hired by the lawyers of Avery Becker to give my insight into this case and to review work done by the prosecution, as well as give my expert opinion on this case.
Have you ever testified as an expert in court?
I have several times.
In what areas are you regularly qualified to provide testimony as an expert?
I am regularly qualified in crime scene reconstruction. I have been admitted 8 times. Cell phone tower analysis, I've been admitted 5 times. And general police tactics, and I've been admitted 12 times.
Which courts have qualified you as an expert in these 3 areas?
My education, as well as my hands-on experience with these areas, have qualified me before as an expert.
And Mr. Van Owen, in what courts have you been qualified?
I've been qualified in the district courts of Colorado, Kansas, and Arizona, and state courts of Colorado, Wyoming, Nebraska, and New Mexico.
What is your educational background?
I first got my bachelor's degree from CU Boulder in 2005 in English. And in 2014, I got my master's degree in criminal justice from Ashford University.
Please describe your professional career.
I worked with the Aurora Police Department for 9 months stint in 2005, then became a school resource officer, a private security guard, and then went into private investigation. As well as during this time, I've taught a class in police procedures and police practices at both schools of the Rockies and CU Boulder.
Your Honor, my apologies. Your Honor, at this time, I would move to admit Mr. Blake Van Owen as an expert in crime scene reconstruction, cell tower record analysis, and general police investigation tactics.
Crime scene reconstruction, cell phone analysis, and general police procedures?
Yes, Your Honor.
Is that okay? Any objection?
Yes, Your Honor. I do agree that Mr. Van Owen meets the criteria for an expert under Rule 702 for crime scene reconstruction and general police procedure. However, I would like to do a brief voir dire about CDR data and cell phone analysis.
You may.
Thank you, Your Honor. Now, Mr. Van Owen, you don't list any specific courses you took in CDR analysis
That is correct.
or specific classes.
I'm sorry, could you repeat the question?
You don't list any specific classes you took in CDR data and analysis.
That's correct.
And you don't list any specific training,
That's correct.
nor do you list any specific case experiences.
As a private investigator, I've had experience in this field.
But you don't name a single case for us in your witness statement?
I have been admitted as an expert 5 times.
You don't name a single case for us?
No.
Thank you, Mr. Van Owens. Your Honor, at this time, I would object under Rule 702 to his qualification in cell phone data analysis.
Any response?
Yes, Your Honor. Rule 702 provides that Mr. Van Owen can be qualified as an expert based on his education and experience. As he has testified, he has substantial experience in reviewing police investigations, a significant portion of which in today's modern world includes cell phone related evidence. Therefore, he is qualified to provide an expert opinion on cell tower analysis, as several other courts have concluded.
May I respond, Your Honor?
You may.
Now, opposing counsel is correct that under 702, Mr. Van Owens only needs to demonstrate skill, knowledge, education, experience, or training. Now, on direct examination, Mr. Van Owens did not demonstrate any specific skill, did not demonstrate any specific knowledge. On voir dire, they did not exhibit any specific education or training, and the only experience that Mr. Van Owens has is marginal, only 5 cases, none of which can be named here in court today.
The objection is overruled. And this witness is deemed qualified as an expert to testify through opinion evidence in the areas of crime scene reconstruction, cell phone data analysis, and general police procedures. And counsel, if you feel that his credibility within any of those areas is questionable, you may pursue that on cross-examination if you wish. But there is sufficient testimony to qualify him to testify under Rule 702 through opinions.
Yes, Your Honor.
Please proceed.
Let's talk about your professional opinions in the case. What is your opinion about the investigation conducted by Detective Markowitz?
I believe that the investigation is flawed, incomplete, and it was rushed.
Why do you say that?
Well, I say that because in this case, Detective Markowitz did not verify the screenshots provided by Mr. Fuentes and just took them as they were. It would have been much more simple just to verify the screenshots as just to get his phone.
How else was this investigation flawed?
Well, I'm sorry, could you rephrase the question?
In what other ways did the investigation lack?
Right, so there was a lack of lost evidence by Detective Markowitz, in where pictures of blood splatter, a digital file that was mysteriously corrupted, and lost evidence is just unacceptable. Any halfway competent police department would keep multiple photos of crime scene.
Thank you. Next, let's talk about the police's failure to investigate any other suspects. Earlier, you said that the investigation was incomplete. Why is that?
Well, the investigation is incomplete because Detective Markowitz nor Kyle Kuzak investigated other possible suspects like Blair Rollins, for example.
What do you mean never investigated?
Well, even Detective Markowitz had said that a disgruntled ex-client should be looked into, but neither Kyle Kuzak or Detective Markowitz looked further into Blair Rollins.
did you investigate Blair Rollins?
I did.
What did you do specifically?
I listened to a related trial recording in which a prior client of Mr. Brackman, Jonathan Rollins, was convicted of murder. And Jonathan Rollins is the father of Blair Rollins. And I don't know why the police never investigated Blair for that.
We've talked about your opinions on the investigation. Now I'd like to talk to you about your opinion on Kyle Kuzak's crime scene reconstruction. Did you reach an opinion about his crime scene reconstruction?
I did. My opinion is that the evidence doesn't point in the direction that they had gone.
Why not?
Well, first, Detective Markowitz and Kyle Kuzak make a huge deal about the Ring app notifying Mr. Brackman, but this is incorrect for two reasons. Number one being that they hadn't obtained the complete user account records, which would have told us if the notifications were on from Mr. Brackman's phone. And number two, whether even if Mr. Brackman had seen the notification, that he would have paid any mind to it.
Is there any other reason that you concluded Ms. Kuzak's opinions as wrong?
Yes, Ms. Kuzak's opinion about the knife being from the knife block, the missing spot on the knife block, is just incorrect.
Your Honor, I would ask that my timekeeper bring up Exhibit 6.
Okay.
What is Exhibit 6 a picture of?
Exhibit 6 is a picture of the murder weapon, which is a silver knife.
And have you seen this exhibit before?
I have, when I did my own partial investigation of this case.
Your Honor, I move to admit Exhibit 6 into evidence.
Any objection?
Yes, Your Honor, I object to lack of foundation.
Response?
Your Honor, the foundation was laid as Mr. Van Owen testified that he reviewed this exhibit.
May I respond, Your Honor?
You may.
Proper foundation has not been laid as to who took this photo, when it was taken, and whether or not this is a fair and accurate of that copy of that photo.
Reply to that.
Your Honor, I will lay more foundation.
Okay, please do so.
Mr. Van Owen, who took these exhibits? Who took the pictures of this exhibit?
I believe it was Kyle Kuzak who took pictures of this exhibit.
And is this a fair and accurate representation?
It is.
Your Honor, I move to admit Exhibit 6 into evidence.
Response?
No objection now, Your Honor.
Okay.
Exhibit 6. I'm sorry. Go ahead, finish your statement.
Go ahead.
Exhibit 6 is admitted for all purposes.
I also ask that my timekeeper bring up Exhibit 8. What is Exhibit 8 a picture of?
Exhibit 8 is a picture of a knife block with a missing slot on the top right.
And who took this picture?
Kyle Kuzak.
Have you reviewed these exhibits before?
I have, when I did my own partial investigation into this case.
Is this a fair and accurate representation?
It is.
Your Honor, I move to admit Exhibit 8 into evidence.
Any response?
I have no objection, Your Honor.
Exhibit 8 is admitted for all purposes.
Okay. Using the exhibits, please explain to the jury why Ms. Kuzak's conclusion about the knife do not make sense.
Well, as seen in his Exhibit 6, which is a picture of the murder weapon, the size, brand, dimensions, and style of the knife don't match those seen in Exhibit 8, the picture of a missing knife block, knife block.
And why is this important?
This is important because Kyle Kuzak believes that this is an indication of a struggle, but there's no indication that the knife was from the kitchen. And this, her opinion, lacks it fails to consider that the knife could have been from an outside source.
And what is your expert opinion on how this crime was committed?
Well, from what I reviewed in the autopsy, I believe this is cold-blooded murder. I believe that whoever it was snuck up behind Brackman and stabbed him in the back.
Your Honor. This
Go
witness
ahead.
is not qualified under Rule 702 to give medical testimony, and that includes referencing the autopsy report.
Response?
Wait, can you repeat the objection, please? I'm sorry. It cut out.
Yes, of course. Your Honor, this witness is not qualified to give medical testimony pursuant to Rule 702, and that includes the reference of an autopsy report.
Response?
Your Honor, Mr. Van Owen used the autopsy report to reach his expert opinion, and the autopsy was previously authenticized by other people, and it's reliable. He's simply using the autopsy to provide his expert opinion on what happened at the crime scene.
May I respond, Your Honor?
You may.
No witness in this courtroom has previously brought in the autopsy report. And furthermore, medical information, like in this autopsy report, has not been part of Mr. Van Owen's area of expertise, as he was qualified under Rule 702. Therefore, the fact that he made an expert opinion based off of it is inadmissible.
The objection is overruled. I believe the testimony, the question and the testimony were within his expertise in crime scene reconstruction. And so the question and answer may stand on that basis. And counsel, again, if you wish to pursue this in cross-examination, you're certainly welcome to.
Yes, Your Honor.
Why
Please
did
proceed.
you rely? Why did you rely?
Please proceed.
My apologies, Your Honor. I'm not looking at you. I'm looking at the camera. Okay. Why did you rely on this information?
As I regularly do, I review the autopsy and to reach my opinion of the wound and the reconstruction of the crime scene.
What do you think happened at the crime scene?
Well, based on my review of the autopsy, I believe that Mr. Brackman was stabbed in a downward motion. And this is because the autopsy shows that there was a strong enough force to have nicked the aorta, and to have stabbed with that much force, it would have to have been from behind.
Mr. Van Owen, can you show the jury what the motion of the knife stabbing would have had to look like in your professional opinion?
Sure.
Let the record reflect that Mr. Van Owen has his hands above his head and he is moving them downward as if from a higher position than the imaginary person he is stabbing. You've also been qualified as an expert in cell phone tower record analysis. Did you have any opinions about the location of Avery's cell phone on the day of Mr. Brackman's death?
Right. I do. Well, my opinion is that it doesn't show with 100% certainty where Avery Becker was, only where his phone was. And even this gives more insight into what Avery Becker's alibi was.
And you said that it only shows the location of the phone. What do you mean by this?
Well, as a cell phone regularly does, it will connect to the best connection, not always being the closest one to the cell phone. And an example of this would be if somebody made a call and is right next to a cell phone tower, they could possibly connect to a different one much further away. And that would be because the other one would have a better connection.
You mentioned call detail records. What call detail records are you referring to?
I'm referring to the call detail records of Taylor Perkins.
Why are
Taylor
Perkins call detail records important?
I believe they're important because they give an alibi to Avery Becker. And this is shown by each call that is given from Avery Becker on Avery Becker's phone. There is a corresponding call on Taylor Perkins's phone. And this further, I believe, further strengthens that they were together looking for Avery's phone, and thus is his alibi.
No further questions, Your Honor.
Sorry, Your Honor.
Cross-examination?
Yes, Your Honor. May I request a brief time check before we proceed?
Yes.
Thank you, Your Honor. Now, Mr. Van Owens, I'd like to clarify a few things about what you did in this case before we move on with cross-examination. You never went to the scene.
No, but I did review everything that was given, what was there.
Now, you didn't talk to Kyle Kuzak.
I did not.
You didn't talk to Jordan Markowitz.
I did not.
You didn't talk to Alex Fuentes.
I believe I did. I tried to get a statement from him about the screenshots.
But you were unsuccessful?
Right.
The only two witnesses you spoke with were Avery Becker and Taylor Perkins.
I guess you could say that.
And you never downloaded the contents of a single phone in this case?
No.
You don't present any new records to the court?
No, only the ones that have been presented.
So you only looked over the work that other people have done?
Right, which was lacking in some areas.
But you didn't add anything to it?
No.
All right. And just to clarify, you're being paid in this case?
Right, as regular experts are on the defense.
And you've been paid $7,000?
Right, but that is regular pay for someone in my field of work.
Now, Mr. Van Owens, as we are limited for time, I would ask that you answer my question with yes or no. Now, you make $225 an hour about.
That's right.
Your Honor, may the court take judicial notice that 7,000 divided by 225 is 31?
So noticed.
Now, Mr. Van Owens, that means you only worked 31 hours on this case.
You could say that, yeah.
That's just a little over a day and a half.
Right, that's only the hours that I'm being paid for, yes.
And you claim the police investigation was rushed, right?
Right.
And you say that there are mistakes with the police investigation.
That's correct.
I'd like to talk about mistakes in your investigation.
Okay.
Now, one of the first things you talk about is Blair Rowlands. Now, you've never met Blair Rowlands.
Right.
You've never seen Blair Rowlands.
That's correct.
You have no idea what Blair Rowlands' relationship with their father is like.
No, only from what I have investigated.
You don't know if Blair and his father are close right now.
No, I don't.
You don't know if they've ever been close.
I don't.
And yet you claim that Blair Rowlands has such good motive for this murder.
Right. As would be the majority of people would be if they lost their father.
All right, Mr. Van Owens, I'd like to talk about one final thing. You had the opportunity to correct any mistakes in your report,
Right.
and you called Detective Markowitz Defective Markowitz.
Excuse me?
You called
Could you repeat
Detective
that?
Markowitz Defective Markowitz.
I do not recall saying that.
If I could point the attention of the court to Mr. Van Owens' witness statement and point to lines 219 where it says defective Markowitz. Thank you. Now you say defective Markowitz in your witness statement, Mr. Van Owens?
Right. Could have been a typo. Happens sometimes.
And you didn't correct it.
Could have been autocorrect.
Thank you, Your Honor. I have no further questions for this witness at this time.
Any redirect?
No, Your Honor.
All right, thank you.
May I step down, Your Honor?
You may. Defense, please call your next witness.
The defense calls Avery Becker to the stand. May I proceed?
You may.
Good evening. Could you please state and spell your name for the jury?
Yeah, Avery Becker, Averypecker.
Mr. Becker, you're the defendant in this case today. Why have you chosen to testify?
I've chosen to testify because I'm being falsely accused of murder, and I want to tell my side of the story.
Before you're accused, can you tell us what your life was like as a high school student?
Yeah, I usually hang out with my best friend Taylor Perkins, and we were in mock trial together. Other than that, we usually hang out at the Fry Shack or at the mall.
Did you know Mackenzie Brackman?
Yeah, he was my mock trial coach.
How would you describe your relationship with Mr. Brackman?
We had a tense relationship. I never really got along with Mr. Brackman, and I always disagreed with him.
How did you feel about Mr. Brackman?
Although our differences, I respect him. I thought it was impressive how he could always bring out the mock trial team on top.
How do you feel about his death?
I feel terrible. I feel terrible about his death.
Is there any reason that you would feel so bad for about his death?
Yeah, we'll see that I never really got to apologize for what I did.
What did you do?
Well, after the tournament, we were going over the good and bad points on the whiteboard.
And then what happened?
Well, Coach Brackman said some things. It made me a bit upset, so I stormed out of the practice with the marker still in my hand.
What kind of marker?
At the time, I thought it was a dry erase marker, but it It was a Sharpie.
What did you do with the Sharpie?
I unfortunately wrote "Worst Attorney Award" on the hood of his car.
Why did you write that?
Well, Coach Beckman had lost a big case, and I guess I had a nerve or something. It was a stupid and awful thing for me to do, and I feel terrible about it.
How did you try to communicate this to your coach?
Well, I tried apologizing to Coach Beckman. I sent him multiple texts saying that I would scrub off the paint and that I would get a job so I can repair his vehicle. But he never replied, unfortunately.
Moving on to the day before Mr. Brackman's death, do you remember what you were doing on that day?
Yeah, me and my friend Taylor Perkins were hanging out at the Fry Shack, and later we went to the mall.
Did you two see anyone while you were out?
Yeah, we saw a lot of the people from the mock drill team at the Fry Shack, including Alex and Fuentes. Sorry.
You mentioned Alex specifically. Why is that?
Well, Alex had said some things that made me a bit upset, so I went to the bathroom to cool off, and I unfortunately left my phone with him.
What did you do after you came back from the bathroom?
Me and Taylor left right after.
How would you describe your relationship with Alex generally?
Well, we never really got along. I was never really friends with Alex. He pretends like we were best friends, but truthfully, he was friends with Blair Rowlands.
Now, moving on to the day of Mr. Brackman's death, March 6, 2020, what was the first thing you remember from that day?
Well, I couldn't find my phone.
What did you do about it?
Me and Taylor skipped school, and we went to go look for it.
Where did you go?
We went to the Fry Shack.
Did you find it there?
No.
Did you go anywhere else?
Yeah, we went to the mall afterwards.
Did you continue looking?
No, we couldn't find the phone, so we ran out of places to look.
Did you have your phone at all on the day of Mr. Brackman's death?
No, I didn't.
Now, moving on, Mr. Becker, early in your testimony, you mentioned that Alex was closer with Blair than Alex was with you. Were you and Blair friends at all?
No, not really. Blair was a little weird. He's the person you would vote most likely to become a sociopath or a hitman, like as a joke.
Could you describe Blair's physical appearance?
Well, I guess you would say like me. We had the same body build and height.
Do you know if Blair knew Mr. Brackman?
Yeah, Blair knew Mr. Brackman.
How so?
Well,
Objection, lack of personal knowledge and lack of foundation.
Response?
Your Honor, this was common knowledge of what Mr. Becker was about to explain. Practically everyone in the school knew about it, so it wouldn't be uncommon that Mr. Becker knew of this information.
Response, Your Honor?
You may.
Opposing counsel has not laid the foundation in Mr. Becker's testimony that this was common knowledge. Therefore, there is not the proper foundation to assume why Mr. Becker knows this about Blair Rowlands.
Response?
Your Honor, if you would like, I could lay some foundation onto why Mr. Becker would know this knowledge.
Please do so.
Thank you.
Yes, Your Honor.
Now, Mr. Becker, I am going to backtrack a little bit. Do you know if Blair knew Mr. Brackman?
Yeah, Blair knew Mr. Brackman.
How so?
Well, at the time, it was common knowledge that Coach Brackman lost a big case that ended up sending Blair's father to life in prison for murder.
And do you know if Blair is upset by this?
Well, I would be.
Objection, speculation.
Your Honor, oh, I'm sorry.
Go ahead and respond.
Your Honor, my client is not going to speak to how Blair would have felt. He was going to put himself in Blair's shoes as to if he was in that situation.
Response, Your Honor.
You may.
The question was directly, do you know if Blair was upset by this? There was no reference to putting Avery Becker into Blair Rowland's shoes. Therefore, this is directly speculation because it's asking about Blair Rowland's emotional state of mind.
The objection is sustained. Counsel, you may rephrase the question if you wish.
Your Honor, I'm afraid it looks like my time is up, but thank you. The defense rests, Your Honor.
Oh, okay. Is there cross-exam?
I do have a cross-examination, Your Honor.
Okay. Please proceed.
Yes, Your Honor. Mr. Becker, you love mock trial.
Yeah, I do.
It meant everything to you.
Yeah, I love mock trial.
You did great in mock trial competitions.
Yeah, I would say so.
But even then, Mr. Brackman demoted you to B team.
Yeah.
Later, you were brought back up to A team.
Yeah, I was.
But you were still frustrated with Mr. Brackman, weren't you?
Kind of, yeah.
You disagreed with his critiques of you.
Yeah, I did.
Because you are so great at just making things up on the fly.
Sorry? I have trouble with the question.
You are so great at making things up on the fly.
What do you mean by on the fly? Like on the spot or?
Yes, on the spot.
I would say I'm good at mock trial. I'm good at what I do, but I'm not sure about making things up on the fly. I don't know what you mean by that. I'm sorry.
You ignored Mr. Brackman's critiques of you.
I felt that they were a little unjust and kind of unfair.
But you saw that that frustrated him.
Yeah, I guess it did.
After regionals, Mr. Brackman went so far as to criticize you for your performance.
Yeah, unfortunately, he didn't feel that I did as well as I thought I did.
But here you could not take the criticism.
No, I mean, I tried really hard in mock trial and I was shut down by my own coach.
You called him the worst coach in the state.
Yeah.
You ran out to his car.
Yeah, I did, unfortunately.
In the middle of the day.
Yeah.
And you wrote worst attorney award on his Porsche.
Yeah, unfortunately I did. Like I said,
You wrote this on his private property.
Yeah, I feel horrible about it.
This time,
a lot of dumb things in my life, and that was one of the worst.
This time, he wouldn't let you back onto the team.
No, understandably.
Even though mock trial means everything to you.
Yeah, mock trial was something that I liked doing. I enjoyed mock trial, and I thought I was good at it.
Even though you tried everything to apologize.
I tried to apologize to Coach Brackman for vandalizing his car.
But he wouldn't listen to you.
No, unfortunately, he ignored me, and it made me feel terrible.
So Taylor Perkins is your best friend.
Yeah.
And you claim that you were at the mall at the time of the burglary.
Mm-hmm.
With Taylor Perkins.
Yes.
But even in such a public place, no one besides your best friend can confirm that you were there.
Well, the people in court testifying is just my friend Taylor Perkins here. I don't see anyone else that I saw at the mall that day.
So no one who you saw at the mall that day is here to testify that you were at the mall.
Which day are we talking about?
On the day of March 6th.
Which is
the day of the burglary, the day you were at the mall.
Yeah, I was at the mall.
You do not have a parent here to confirm where you were.
No.
You don't give a timeline of your whereabouts at the mall.
No.
And you don't say when you got home from the mall.
No, I don't.
Now to shift gears a little bit. You say in your affidavit that your mom actually complains about you being on your phone all the time.
Yeah, I guess. I mean, I'm a teenager.
You're a teenager.
Yeah.
You love your phone.
Objection relevance.
Response, Your Honor.
You may.
Your Honor, this is relevant because Avery Becker claims that he lost his phone on the day of the murder. It is relevant to show how much Avery's phone meant to him so that the prosecution can show that Avery would have not just lost his phone the day before the murder.
Response.
Your Honor, the fact that Avery Becker, being a teenager and happened to have somewhat of an attachment to his phone, does not necessarily show that on different circumstances, as uncommon circumstances, my bad, that he would have his phone with him at all times. It just shows that typically he would. In this case, he did not.
Objection is overruled.
Mr. Becker, you didn't notice your phone was missing until the morning after you left the fry shack on March 5th.
No, I didn't know it was missing.
And that means you didn't even look at your phone after you left the restaurant.
No, because I was with my best friend.
You didn't look for your phone while you were driving home from the restaurant.
No, I didn't.
Or when you got home.
No, I didn't.
Or after dinner.
No, I didn't.
Or before you went to sleep.
No.
How convenient. No further questions, Your Honor.
Any redirect?
No, Your Honor.
Okay, Mr. Becker, you may step down.
Thank you, Your Honor.
Does the defense have any further witnesses?
No further witnesses, Your Honor. The defense side rests.
All right. Okay, if this were a real trial, the case would go to the jury with instructions and so on. But since this is mock trial, everybody can relax. And let me say.
Actually, do we have time for closing arguments?
Yes.
We sure do.
Yeah. And I'm sorry. Closing is not a. Yeah, that's separate timing. So.
Thank you, Your Honor.
My mistake.
Apologies.
Go ahead. Prosecution, your closing argument, please.
Yes, Your Honor. Permission to proceed?
You may.
On March 6th of 2020, an arrogant high school student unable to accept criticism resulted in their mock trial coach's body dead on his patio, a bloody kitchen knife lying next to him. Members of the jury, not only did we show you today that Avery Becker had the motive, the means, and the opportunity to commit this crime, but we showed you how resentment seethed into anger and anger exploded into fury. I'd like to direct your attention to jury instruction number 7. The definition of murder in the first degree. Now, the prosecution and the defense agree on the place and time of the murder, that the perpetrator broke into Mr. Brackman's house, intending to, at a minimum, destroy, and that Mr. Brackman was killed as a result. The only issue that the prosecution and defense disagree on is identity. Today, the prosecution showed you beyond a reasonable doubt that Avery Becker is the perpetrator. Kyle Kuzak and Detective Markowitz, the two most experienced investigators in the court, both identify Avery Becker as the intruder, From the cell phone data to the plan Avery set into play and to the pattern of the crime itself, all paths lead to Avery. Avery Becker tried to tell you that she's innocent. She tried to tell you that he did some stuff that he's not proud of, such as vandalism, as the defense said in their opening statements. However, the vandalism that Avery was not proud of occurred just days before this other vandalism crime against Mr. Brackman. Avery Becker has no explanation to how her phone was tracked from his house to Mr. Brackman's house. And he has no explanation for how not one person knew he was at the mall that day, except for Taylor Perkins, Avery's best friend who knows Avery better than anyone. But even they were able to consult each other before talking to the police. They couldn't come up with an actual timeline for the alibi. Now, the only other witness in this case is Professor Van Owens, who conducted a brief examination, talked to two people, and came up with the conclusions that don't refute the bottom line, which is the culmination of these facts point to one person, and a couple of scattershot hypotheticals don't establish reasonable doubt. They don't refute the fact that either way, Avery still had the means, the motive, and the opportunity. Now today, Alex C. Fuentes told you exactly why Avery committed this crime. Alex showed you how Avery's feelings towards Brackman evolved from mere resentment, as Avery could not accept Coach Brackman's criticisms in practice, to anger, as Avery grabbed a permanent marker, stormed out of practice in the middle of the afternoon in broad daylight, and destroyed the hood of Mr. Brackman's Porsche. And then finally to fury, as Avery texts Alex, well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house. That'll show him. That'll show him for taking away something that Avery told you meant everything to him. This is what brought Avery over the edge. That'll show him for not giving Avery the chance to bribe his way back on the team. After seeing his house, Mr. Brackman would never again take this opportunity away from Avery, because Avery planned to teach him a lesson. It turned out to be a deadly one. Avery Becker entered Mr. Brackman's house on March 6th, but this wasn't a surprise. Why? Because resentment, anger, and fury. Because when Mr. Brackman doesn't let Avery do what Avery wants, he goes to get revenge. On March 6th, Avery tried to get revenge, to teach Mr. Brackman a lesson, but this time it went too far. We showed you the identity, and now you have to convict Avery Becker of second-degree burglary and murder in the first degree. Thank you. Your Honor, may I ask that my remaining time be left for rebuttal? I accidentally did not ask that before I went because of, yeah.
You may. I will grant you that concession. It technically does not comply, but you did ask before your presentation ended. So yes, how much time, timer, how much time is left in this part of the closing?
"45 seconds, Your Honor."
Okay. Defense, closing argument, please.
May I proceed?
You may.
Taking the easy way out leaves reasonable doubt. Your Honor, ladies and gentlemen of the jury, my name is Daniela Guadana, and today I represent my client, the defendant, Avery Becker. After my colleague and I finish our closing arguments, you will have the duty to decide whether the prosecution proved beyond reasonable doubt that my client murdered Mr. Brackman. Instruction number 2 says, reasonable doubt is a doubt based on reason and common sense, which arises from a fair and rational consideration of all of the evidence, or the lack of evidence. It is a doubt which is not vague, speculative, or imaginary. After taking the easy way out, the prosecution and its investigators failed to discover little evidence. They failed to discover reliable evidence, and now a murder is on the loose. After consideration of such evidence and lack of evidence, You cannot find beyond reasonable doubt that my client committed a burglary, let alone a murder. Let's start with the evidence you did hear. The prosecution was never able to disprove Mr. Becker's alibi witness on the day of the murder. Ms. Taylor Perkins told you how well she truly knows Mr. Becker. He is a very rational person, rational enough to have never even thought to commit murder. Ms. Perkins confirms that Mr. Becker lost his phone and did not have it on him on the day of the murder. You then heard from expert witness Blake Van Owen. Mr. Van Owen helped us see how the police investigated with tunnel vision, only considering Mr. Becker as a suspect. Instead, there was an even better alternate suspect, Blair Rollins. She had motive, intent, and opportunity. Mr. Blake Van Owen testified to this. He also testified to the fact that Mr. Brackman was Blair's father's attorney when he was convicted for murder. Despite this, the prosecution never looked into them. They took the easy way out. You then heard from the defendant himself, Avery Becker. He told you how he is a normal high school student who absolutely loves mock trial. Devastated by being kicked off, he did everything to try to make it right. But at the end of the day, this devastation is nowhere near enough to have made him want to harm Brackman in any serious way. Besides, who would kill someone for being kicked off of a mock trial team? Certainly not my client. You also heard from the prosecution witnesses, and none of them provided you proof beyond reasonable doubt that my client murdered Mr. Brackman. Alex Fuentes came here today and provided you screenshots of an alleged text conversation between him and Mr. Becker. But Detective Markowitz himself and Blake Van Owen testified that these screenshots were never verified. Ms. Fuentes had bias against Mr. Becker. Her friendship with Blair reassured this. They clearly set up my client to take the fall when Fuentes herself and Blair Rollins stole my client's phone at the Burger Shack. You then heard from Kyle Kuzak, who came here today to convince you all of her conclusions regarding the crime scene. But the credibility of her is questionable. On cross-examination, she did not recognize her own exhibit. She did not recognize her own spreadsheet, and she forgot that she added Blair Rollins. What does this mean? She is not credible. She also came here today to tell you that the knife was from the crime scene, simply because of a knife block. But Blake Van Owen testified that the murder weapon does not match the missing knife slot in the knife block itself. Detective Markowitz came here today to tell you all about the evidence at the crime scene, which of course includes the completely unrecoverable and lost exhibits. He told you that the cell phone tower confirms that Mr. Becker was at Mr. Brackman's house at the time of the murder, despite the fact that cell phone towers do not always connect to the nearest cell phone tower. Plus, the records only show where my client's phone could have been, not where my client was. And as you heard from the defense witnesses, Mr. Becker never even had his phone. Instead, Blair Rollins was the one who had much more motive than my client. She was a heartbroken daughter, completely overcome with emotion, waiting anxiously to get revenge on Mr. Brackman. The prosecution talked about motive, means, and opportunity. What they do not realize is that Blair Rollins had all three. She had them in such a big way. Despite all this, Detective Markowitz never followed the evidence straight to Blair Rollins. He took the easy way out and created reasonable doubt. Your Honor, members of the jury, today you heard about an investigation that was full of error and bias. It was botched from the start, dripping of reasonable doubt. I remind you, taking the easy way out leaves reasonable doubt, and now a murder is on the loose. You must find Avery Becker innocent. Thank you.
Your Honor, permission to proceed with rebuttal.
You may.
Thank you, Your Honor. Members of the jury, today we did show you that Avery Becker had the means, the motive, and the opportunity. Avery had the means because there was a missing kitchen knife that Markowitz showed you in Mr. Brackman's house. Avery had the motive through resentment, anger, and fury, and Avery had the opportunity because of the text messages that he sent to Alex Fuentes the day before the murder. Now, the only person here to say that Avery Becker didn't have the opportunity is Taylor Perkins, someone who the defense says knows Avery better than anyone, loves Avery better than anyone. So obviously this is going to be a biased witness. And in addition, the prosecution pointed to Blair Rowlands' father's bias, not Blair Rowlands' actual bias. They did not talk about anything about Blair Rowlands' motive. Thank you.
Okay, now I think this process, this proceeding has been concluded. And while the scorekeepers are finishing up on their scorecards, what I would like, well, normally what I do is I ask the gallery to stand up and give a round of applause to the teams. And in this case, that applause would be richly deserved. And I'm not sure how to do that in this platform, but I would like to express my appreciation and channeling through me the audience appreciation for this performance today. I'll make some more specific comments later, a couple of them, but I was impressed. I think I have some problems with this platform. I've used it a lot in my actual job as an attorney, but it's not perfect, and it I hope will be behind us at some point in the near future. But I think all of you performed well, notwithstanding the limitations of the platform. And I will give the scorekeepers an opportunity to provide their comments, and then I'll provide a couple of closing ones. So right now, if Jess, if you could let me know when you have all of the score sheets, then we'll proceed to the chat back.
So we will
Meanwhile,
actually be doing verbal confirmations from my 4 scorers that they have submitted. Once I get verbal confirmation from those 4, we will move on.
Okay.
I've already submitted mine.
Cassie Picard and I also have submitted mine as well.
Thank you.
And sorry, I'm still working on mine, but you guys can keep talking.
Not a problem, Tony Ann. Thank you. And I believe I had one more scorer.
I'm almost done, but you guys can keep talking. That's good.
Thank you very much.
Don't rush. Make sure you're happy with your scorekeeping.
David, during the lull, am I okay to offer feedback from one of the scorers? Or we wait until the very end?
Yeah, wait till all of them
Okay.
are in.
Perfect. Nope, not a problem.
That's the procedure. You can think about what you're going to say.
I'll keep thinking.
Okay.
I just submitted the score sheet, but I forgot to write in, it looks like, the names for the closing arguments. Is there a way to edit it?
I will pass on that note to Ashley and Amy.
Okay, thanks.
Do we have one more scorer?
Yep, I'm done. I submitted and I had the same issue. My names were kind of confusing at the end there, so.
Thank you, Tony Ann. We have all 4 confirmed.
Okay. Let's go ahead and proceed with the feedback portion. I would urge the scorekeepers to try to keep it brief. We're supposed to limit your comments to 2 to 3 minutes. And I know some judges actually ask the timers to time you. I'm not going to do that to you. So you may take a little more time than that, but I would like you not to expound too much, though you may want to. So please proceed in whatever order you would like. Cassidy, why don't you go first?
Sure, I'll be very brief. Great job to everybody. It takes a lot of hard work, time, energy, everything to get up here and do what you guys did today. So great job, and especially dealing with COVID and having to deal with the technology. Just great job all around. Every one of you all know the material better than we do. So when you get up there, just be as confident as you can be, because you could tell us pretty much make up anything you wanted and I would have probably believed it, just because you guys have spent so much time invested in it. So just stand up and speak with confidence. To the extent I could kind of tell that some people are reading off of stuff. And if you are, I mean, you kind of have a cheat here to where you can put it behind your screen. Maybe do that as you move forward. I mean, I'm not encouraging to read off of sheets, but to the extent you are, maybe do it in a stealthier manner. Otherwise, yeah, great job, everybody, and good luck moving on if you're moving on. So good job, everyone.
Next, go ahead, Alexandria. You're muted.
All right, there we go.
That's better.
So yeah, everyone, I was really impressed. This is my first time doing the scoring for one of these, and I'm blown away by how well prepared and great all of you did, that you were able to, rattle off the rules of evidence, the specific numbers. I was super, super impressed. I think same thing with Cassidy. The only thing I really noticed that I would have had any critique at all was some of the reading off of sheets. But beside that, I would be very hard pressed to find anything wrong with any of your arguments or professionalism. I thought it was yeah, I was blown away. Can't believe how great you guys all did. So yeah, good job and keep up the good work. Are we supposed to give like direct mock trial members feedback or just overall groups?
Well, if you have comments, positive comments
Go
about
ahead, Judge.
a couple of them, yes, that's what I'm planning to do.
So for Daniela, the one thing that really stuck out to me was that during your cross-examination and direct examination, you were very objective, and which worked very well, I thought. And then the juxtaposition to the closing argument, where you were very, I mean, not super emotional, but you were more, there's more passion in your argument. It stood out to me a lot and made it a lot more persuasive, the closing argument, that you were able to do that. And I thought that was pretty cool.
Okay.
Yes. Again, like everyone has said, I thought y'all did a fantastic job. You knew your facts, you knew your rules of evidence, you knew which exhibits you wanted to present. You present them in a timely manner, and that is really appreciated. Chloe, I thought you did a fantastic job answering every question that everybody threw at you, whichever direction it came from. I was really impressed with that. And I thought everybody did really great. I especially liked the fact that you tied your closing back to your opening and you followed your themes all the way through the trial itself.
Hi, everyone. So congratulations. I think this is tough. I think it's especially tough with technology. You're trying to, keep your eye on the camera, mute yourself, unmute yourself. I mean, I get it completely. A couple of comments, and I think this is kind of true overall. Be invested and excited, but don't be angry or upset. You as an attorney in particular need to remember that you are there for a reason, and you can't have that personal vested interest in being angry. I think it was kind of interesting. You don't always like your witness, but that doesn't mean you have to show them that you don't like them. And in particular, if you have your own witnesses you don't like, we definitely shouldn't see that. I shouldn't see that, wow, this person on the stand is really a jerk and we all don't like you, but I shouldn't see that from the attorney. You should just be calm and collected. The other piece is control your witnesses, especially in cross-examination. I saw a lot of, during cross-examination on this kind of technology, it's perfect because the person speaking is the person that you see in the head. During cross, I should see just the attorney and snippets of the witness because you are controlling that witness. I just want yes, no. I don't want you explaining, oh, but, and then I was. That doesn't work. And it's the opposite for when you have your own witness. You don't lead them. You tell them the question and let them talk. It should be all of them on the other side. But yeah, overall, really, really great. The witnesses were great and fantastic. You guys did a good job. So thank you for your time.
Okay, I echo most of what I just heard. This was as you know from my introduction, I've been doing this a long time, and this was a well-balanced, well-coached, and well-presented proceeding on both sides. And the cross-examination, which is something I really like to observe, was excellent. A couple of really great battles, as Tony Ann alluded to, between the witness and the cross-examining attorney. A couple of performances that I would like to mention specifically is the two witnesses, as it turns out. Let me see, Louis Sharp as Cifuentes, Alex Cifuentes. I think you were great. I think you ought to think about, if you don't go to law school, go to drama school. You did a great job in a low-key way of portraying somebody that you self-identified as a loner and somebody that nobody else likes. I mean, you exhibited in a subtle way why nobody likes your character. I thought you did a great job of that. And that was very appropriate to this role. You did a great job. So my compliments to you specifically. And the other witness that I was impressed with particularly was Chloe. And how shall I say this? I think you came across as an unusual expert witness. Experts in real life are not really very likable people. They are focused, they are intense, they are very confident, sometimes bordering or even past arrogant. You were the opposite of that. You were particularly on direct, of course, which was appropriate. You were personable, you were kind of laughing and presenting well-reasoned, well-thought-out opinions in a very friendly way. And at the end of your performance, I said that worked. Normally, it wasn't what you usually see, but it worked with you. You made it work being a nice person. You turned some of that off appropriately during cross-examination. That's what you should have done, and you did it. Compliments to you as well for that performance. I don't urge you to become an expert witness as your profession, but you did a great job today, and I know you'll continue to do a great job in your future roles in this proceeding. The other thing I'd like to mention, really, it's one thing, but it involves two people, and that was the opening for the prosecution by Jordan. Is that right?
Yes, hi, I'm sorry, my mom is here, so I'm also trying to pick up all of my stuff because I really don't want to keep her waiting.
Okay, all right. Okay, well, you and Zarina, right?
Yes.
Great name, incidentally. You did a great job of working together. There's great bookending. I forget which one it was of the scorers, but that's where you echo the same themes in your closing that you mentioned in your opening. Great job. And also, both of you, lots of passion, which is something else that was mentioned by a scorer. Good, positive, effective use of emotion. You were on the prosecution. Prosecution always has a tough case in a criminal trial. And you put appropriate passion and emotion to use in presenting both the opening and the closing. I think that was particularly the case. But your attention to the realities of the testimony and so on, and your weaving of the arguments and the opening statement and then echoing again in the closing was just really impressive. So my compliments to both of you for working together. That was good teamwork, clearly. And I appreciate it. I do this because I enjoy it. And this one was really enjoyable, particularly for those reasons that I've just expressed. So thank you all. And thanks to the people that support you, who I hope, if they're not listening now, I'd like all of the team members to tell your parents and your friends and your other relatives and family members that I appreciate their commitment to this as much as I appreciate yours. You do a lot of the direct work, but you couldn't do it without their support. And I appreciate it because that's a major part of the quality of this presentation today, was the support that I don't have any details on that, but I could tell it was there. So if you could pass that on, I would appreciate it. Otherwise, I think we're done for the evening. If you were adults, I'd say go get a martini, but don't do that. I hope you both advance. I think you both deserve it. That may not be possible under the scoring system that we use here. But anyway, my congratulations to everybody. So, good night.
Thank you so much.
Thank you so much.
Thank you, Your Honor.
Thank you.
Thank you, Your